if you can hear me. Yes, Karen is anxious. Hey, I turn my head to the left. I already see some thumbs up. Okay. What's good with it? What's good with it? Karen J was first. Woo! Woo! You digging me? Hey. You get your soda. It's about to be a long one. Right, right. Yes. Hey, Shaw Baby One. Yes. We said I'm here with the headphones on the bed. Love you from all the bush. Yes, thank you. Love you too, Haunty. And Shout T. Shout Baby One and Shout T is in the building. So y'all, okay. So I did say that thought she would answer the motion for new trial and the acquittal the day at the hearing, right? I'm a little close. She answered the day of the goddamn sentencing. Judge Ann Donnelly is she got 30 rounds. I got let me see. I don't even want to say that shit no more. I ain't never said it in the first way, but fuck that. Scratch that. I'm gonna have to edit that out. Oh hell no, don't say that. These motherfuckers, boy. So this should be an interesting read. So she combined them in one, right? So I was going back to fix my title. So I was letting you know. So I got on this to let y'all know that she answered both of them in one. Yeah. Let's see what we got. Let's see what we got. Mm, 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 mm. It just came up. I don't know what the fuck is wrong with all these pages. Well, how you put that reading thing on here? We all feel cheated if I find out how to do the reading thing. How they do the reading thing? What the fuck you have to do to get the reading thing on your screen? Like how they do that? Let me see. Is it up under him? The reading thing? No. How the reading rainbow thing? Shit. No, ain't none of that. Damn. Okay. Let's get on to it. Here we go, here we go, here we go, here we go, here we go. Yeah, it was. All right. The defendant, an international music star. And I want to get through as much as I can because I want to kind of see what is in her mind. So this is from the judge. I want to see what kind of time she's on. Is she with that bullshit or what? Okay, it says Ann Donnelly. It says the defendant, an international music star. Let me see. Let me make it big. Hold on. The defendant, an international music star, was charged with using his fame and organization to lure young people into abusive sexual relationships, a racketeering enterprise that the government alleged spanned about 25 years. Over the course of a 6-week trial, the government presented the testimony of 45 witnesses and introduced hundreds of exhibits, including written, video taped, and audio taped evidence of the abuse to which the defendant, enabled by his employees and associates, subjected his victims. On September 27, 2001, a jury convicted the defendant for that conduct. Before the court are the defendant's motions pursuant to Federal Rules of Criminal Procedure 29 and 33 for judgment of acquittal, or in the alternative for a new trial. So remember, I told you a long time ago, they filed those two together, right? Motion for acquittal and for a new trial, just in case if one is denied or granted at a later date, then the motion of new trial will be filed in time, right? So they have to do that. It says, in seeking this relief, the defendant attacks almost every aspect of his trial, the sufficiency of the evidence, the credibility of the witness, his trial lawyers, competence, and the court's evidentiary rulings. The government opposes. For the reasons explained below, I deny the defendant's motion in their entirety. So she denied both of them. The indictment. The defendant was charged in a third superseding. Okay, well, I don't got to read no indictment. We don't went over that. About the Curcio hearing, we know about that. I ain't got to read all that. Fuck that now. Pre-trial motions, we don't need to read those. Jury selection, we don't need to read that. Hold on, wait a minute. Maybe, wait a minute. The trial, we don't need to read that. I'm trying to get a sense of what she's thinking now. The herpes. Hold on. Those about each. The witnesses that took the stand. Stephanie, Sonia, Alexis, Lewis. And unfortunately, we're going to still be talking about New York because she still got the appeal. Well, we can take a break after this because the appeals is up next. So once they get to that area, that time frame, then we'll be back on there. That's Faith. Other evidence. Okay. Let me see. Do you want to hear some about the evidence? Let me see. Defense case. Verdict. Okay. All right. Let's get to her part. Let me see. Damn, she wrote a lot. Hell, that's page 32 just from her shit. Okay, discussion. Motion for acquittal. The defendant makes a Rule 29C challenge to the sufficiency of the evidence for every count of the indictment, the racketeering count, and each predicate act, and all 8 Mann Act counts. These challenges are unavailing. Oh, wow. She sounds pissed. Oh, boy. She sounds pissed. A court evaluation, a Rule 29C motion views the evidence in light most favorable to the prosecution and will uphold the jury's verdict if it determines that any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Case law. To succeed, any Rule 29 motion must demonstrate that viewing the evidence in the light most favorable to the government, no rational trier could have found the essential elements of the crime charged beyond a reasonable doubt. Viewing the evidence in the light most favorable to the prosecution means drawing all inferences in the government's favor and deferring to the jury's assessment of the witness's credibility. Case law. A court must consider the government's case in its totality rather than in its parts, and the sufficiency test may be satisfied by circumstantial evidence alone. Case law. Thus, a defendant challenging the sufficiency of the evidence bears a heavy burden. Case law. The defendant has not sustained his burden. A. Racketeering. The RICO statute makes it unlawful for any person employed by or associated with any enterprise whose activities affect interstate or foreign commerce to conduct or participate in the conduct of such enterprises affairs through a pattern of racketeering activity. The statute further defines enterprise to include any group of individuals associated in fact, although not a legal entity. As the Supreme Court has observed, the enumeration of included enterprises is obviously broad, and the term any ensures that the definition has a wide reach. Case law. The Second Circuit on April 12, 2022, Congress defined enterprise for purposes of RICO broadly, and an association in fact enterprise must have at least three structural features: a purpose, relationships amongst those associated with the enterprise, and longevity sufficiency to permit these associates to pursue the enterprise purpose. Remember, I did a live and I pulled that up and I said, oh wow, they had made some type of changes, definitions to the law recently with regards to RICO, where that's and those are the three things that I went over. Well, that's she used those as well to make her case here. All right, it says an association, in fact, enterprise is a group of persons associated together for a common purpose of engaging in a course of conduct. Case law. An association, in fact, enterprise is simply a continuing unit that functions with a common purpose. The Supreme Court has consistently rejected arguments aimed at narrowing the statute's broad reach. Thus, an enterprise need not to have a I can never say that. Hey, wait a minute. Her hierarchy. What is that damn? Hierarchical. Okay, hierarchical structure. Okay. On a chain of command, decisions may be made on an ad hoc basis and by any number of methods, by majority vote, consensus, a show of strength, etc. Reference. Further, members of the group need not have fixed roles, and the group need not have a name, regular meetings, dues, established rules and regulations, disciplinary procedures, or induction or initiation ceremonies. While the group must function as a continuing unit and remain in existence long enough to pursue a course of conduct, nothing in RICO exempts an enterprise whose associates engage in spurts of activity punctuated by periods of quiescence. Yeah, quiescence. I'm sorry. Shit. Okay. Boyle also makes it clear that the RICO statute is not limited to groups whose crimes are sophisticated, diverse, complex, or unique. For example, a group that does nothing but engage in extortion through old-fashioned, unsophisticated, and brutal means may fall squarely within the statute's reach. Again, this backdrop, I will address the defendant's argument that the government did not establish the existence of an enterprise, that the enterprise's activities affected interstate or foreign commerce or a pattern of racketeering activity. The enterprise. In challenging the existence of the enterprise, the defendant does not appear to contest the evidence that he was at top of an organization and that he had groups of employees, an inner circle who worked to promote the defendant's music and brand and to tend to his personal needs. Relying on First Capital Asset Management, Inc. versus Sandalwood. Oh, Lord, that was cold up. The Second Circuit 2004, the defendant insists that the government did not prove a RICO enterprise. In Satinwood, the Second Circuit stated that for an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such properties. Case law. Citing this language, the defendant contends that the government had to establish the defendant, his employees, and entourage came together with the common purpose of recruiting women and girls to engage in illegal sexual activity and produce pornography, not merely the broader purpose of promoting defendant's music or brand. To the extent that Satinwood imposes a more stringent standard for pleading the existence of an enterprise, it conflicts with the binding Second Circuit and Supreme Court precedent, as several district courts in this circuit have found. Case laws and case law. In Texner's Export, the Honorable John G. Cotel explained that in Turcotte, the Supreme Court distinguished the elements of enterprise and patterns of racketeering. The enterprise is an entity, for present purposes, a group of persons associated together for a common purpose in engaging in a course of conduct. The pattern of racketeering activity is, on the other hand, a series of criminal acts and defined by the statute. The former is proved by evidence of an ongoing organization, formal or informal, and by evidence that the various associates function as a continuing unit. The latter is proved by evidence of the um, requisite, number of acts of racketeering committed by the participants in the enterprise. One element addresses group organization, while the other addresses conduct. In Turcotte, the Supreme Court held that individuals in an enterprise must share a common purpose to engage in course of conduct. The court did not say that the course of conduct must be fraudulent. The Satinwood language conflicts with well-established precedent that RICO covers both legitimate and illegitimate enterprises. The United States Supreme Court has held that RICO protects the public from those who would unlawfully use an enterprise, whether legitimate or illegitimate, as a vehicle through which unlawful activity is committed. Case law. It is true that members of an association effect enterprise, such as now charged, must be connected by a common thread of purpose, and one might often expect such a purpose to be of a criminal nature. But the ultimate question is whether an association in fact exists. For this is not required that each participant have a separate mens rea, so long as each can reasonably be said to share in common purpose. And mens rea means the intent or the purpose of whatever. Let me see. Because she's saying a whole lot of stuff. Let me get down to what she comes. Okay. 'Cause I want to get, I'm trying to get her mental state right now. So I'm just trying to. Okay, so she rejected that. So let's see what else she rejected. She says, I also reject the defendant's claim that one of the enterprise objectives promoting the defendant's music had no nexus to the underlying racketeering activity. In this circuit, the nexus between the RICO enterprise and the predicate racketeering acts may be established by evidence that the defendant was enabled to commit the predicate offenses solely by virtue of his position in the enterprise or involvement in or control over the affairs of the enterprise, or that the predicate offenses are related to the activities of that enterprise. The jury could rationally find both that the defendant was able to commit the predicate acts, predominantly illegal sexual activity with women and girls, because of his leadership position and control over the affairs of the enterprise, and that his underlings enable his commission of the predicate acts. The jury could rationally find that Hartman was able to sell drugs by virtue of his rank within the gangs, and okay, they're talking about a case law there. The government will try to prove that defendant's debt collection was successful. Okay, she keeps referring to the correlations between the damn case law and what happened here. So let me see. And I'm also looking for appellate issues. Okay, I'm trying to see if you know what J-Bo gonna do. Sorry about that. I got a drink. The defendant employees recruited young women and girls, including by locating them in audiences of the defendant's concerts and inviting them backstage to parties, by passing them notes with the defendant's phone number, and by trolling shopping malls and places like McDonald's and handing out the defendant's contact information. The defendant's employees arranged travel for his victims and enforced his rules. In turn, the defendant controlled his employees and ensured they implemented his rules. He punished them when they did not enforce the rules, for example, by withholding their pay. Okay. Testimony by Susan Mayweather about the defendant fining her for having discussions with his girlfriends or by requiring them to write letters falsely incriminating themselves. Testimony by Copeland about the defendant ordering her to write a letter falsely stating that she had stolen from him. The defendant also argues that the government failed to prove the enterprise distinct from the defendant because the members of the enterprise, the defendant's inner circle, associate together for no purpose other than to carry out defendant's needs. The cases on which he relies, however, are distinguishable, as they involved enterprises that consisted merely of a corporate defendant associated with its own employees or agents carrying out the regular affairs of the defendant. Whoa, okay. Okay. As the Second Circuit explained, because a corporation can only function through its employees and agents, any act of the corporation can be viewed as an act of such an enterprise, and the enterprise is in reality no more than the defendant itself. Case law. In the Second Circuit, the distinctness requirement bars a corporate entity from being named as both the defendant person and the enterprise on its own. Let me see. Scrolling through. Okay. Defendant disputes. I'm trying to get more. I'm trying to go beyond like what she keeps citing for as what she's using. I'm trying to get an idea of how she's thinking. Okay, can I have it here? Transportation goods. Okay, let's see what she says about this. At trial, the government established that members of the enterprise arranged travel across states and internationally for the defendant, other members of the enterprise, and the defendant's victims. As explained in more detail below, multiple predicate acts allege that the enterprise members arranged the interstate transportation of defendants victim in violation of the Mann Act. That evidence, which the jury credited, is sufficient to establish an effect on interstate commerce. Okay, so J-Bo, that's not going to be a good appellate situation right there. So let me keep going. God, only requires a minimum effect on interstate commerce. Okay. Patterns of racketeering. What's related to the enterprise? Okay. Now, let's get to the bribery, right? Because this is Django number one. All right. Bribery. Racketeering Act 1 charged the defendant with bribing a public official with the intent to influence the creation of a fraudulent identification document for Aaliyah. The defendant argues that the evidence did not prove that he caused Demetrius Smith to pay a public employee to secure identification for Aaliyah. Specifically, the defendant contends that the record does not show that he knew of or facilitated the bribery. He cites portion of Smith's testimony, including Smith's testimony that Daryl McDavid gave him the cash to pay the bribes and that he was not positive whether he discussed the bribery with the defendant. The evidence viewed as whole sufficiently tied the defendant to the bribery. Oh boy. Hold on. Because you know we done did our appellate work, so he's going back to see. Lord have mercy. Indeed, there was ample evidence from which a rational jury could conclude that the defendant knew of and facilitated the bribery. So she's tying it to the bribery. After all, the defendant was the only person who stood to gain from the bribery. Remember the three B's, right? The behest, the benefit, on behalf. Okay. He feared that Aaliyah, then only 15 years old, was pregnant, which would have revealed the defendant's sexual relationship with her. As he told Smith, he needed to marry Aaliyah to protect himself. Smith, the defendant, and McDavid discussed how to make the marriage happen. Oh Lord, McDavid is with Judge Ann. Oh, she done put his name in him. Oh, hell no. Oh, McDavid. Oh, no wonder you over there acting like a damn fool. make marriage happen, especially since Aaliyah was too young to be married without parental and judicial approval at the time. Smith suggested that he could obtain fraudulent identification to enable the defendant to marry Aaliyah. The defendant was part of the group that drove to the welfare office and a FedEx office to get Aaliyah's fraudulent identification. Oh, he said the defendant was part of the group that drove to the office with them. Oh. Using those documents, the defendant and Aaliyah applied for and received a marriage license at the Maywood City Hall. After official recommended by the defendant's friend conducted the hasty ceremony that took place in the hotel room. The jury was entitled to infer from this evidence, including the defendant's obvious interest in the protecting himself, that he knowingly participated in or facilitated the bribery. Case law. A defendant's knowing and willing participation in a conspiracy may be inferred from his presence at the critical stages of the conspiracy that could not be explained by happenstance, and may also be established by the evidence that the defendant participated in conversations directly related to the substance of the conspiracy or engaged in acts exhibiting a consciousness of guilt. So remember when I always used to say, who is at the other end of the evidence? Who is standing in that evidence right there? That's what she's pretty much saying. When she said, may be inferred from his presence at the critical stages of the conspiracy that could not be explained by happenstance. Meaning, who was there at the evidence? You know, that's what that meant. To be sure, Smith, a recalcitrant and combative witness. Oh yeah, she real pissed. She real mad. She done called this man a recalcitrant or whatever and combative witness, sometimes hedged about the extent of the defendant's role in the bribery. I actually didn't have any discussion with Robert. It was with Daryl. I'm not sure if Robert was there. At other times, he confirmed that the defendant was present during the bribery conversation. I don't remember precisely each time, but I'm pretty sure the defendant was there. I'm pretty sure the defendant was there with me, so I guess I say yes. In deciding a Rule 29 motion where there are conflicts in the testimony, the court must defer to the jury's resolution of the weight of the evidence and the credibility of the witness. A jury is entitled to believe part and disbelieve part of the testimony of any given witness. Case law. Smith was explicit that he did not want to testify. Yes, I don't want to be here, period. And that he was uncomfortable testifying about the defendant's marriage to Aaliyah. I am uncomfortable with this, Your Honor. I'm truly uncomfortable. We are continuously talking about Aaliyah. Her parents are not here, and I don't understand why I got to do that. Moreover, he was reluctant to incriminate the defendant, having known him since 1984, as just like his brother. A rational jury could credit the portions of Smith's testimony confirming the defendant's participation in the bribery and reject his conflicting testimony. I know damn well that ain't nothing else that just came in. Oh, okay. The defendant's further argument that the predicate act of bribery lacks vertical and horizontal relatedness is also unpersuasive. As explained above, vertical relatedness may be established by the evidence that the defendant was enabled to commit the predicate offenses solely by virtue of his position in the enterprise or involvement in or control over the affairs of the enterprise, or that the predicate offenses are related to the activities of that enterprise. So remember, we always talk about the relevance. Now in here she's talking about related, right? Reliable, related, reliable. Well, what is it? 3 hours? Baby, I'm tired. You know them 3 hours. That. All right. It says, in this case, the defendant was able to commit bribery because of his position as the head of the enterprise and his ability to direct the members of the enterprise to do his bidding. Further, the jury could reasonably find that the bribery was necessary to further the enterprise. The marriage to Aaliyah protected the defendant, his image, his career by shielding him from the consequences of having sex with the minor, prison, shame, and disgrace. The evidence also established horizontal relatedness. The defendant and his associate committed the bribery as part of and in order to facilitate the defendant's sexual activity with women and young girls, including illegal sexual activity. Reference, it says predicate acts are horizontally related when they have the same or similar purposes, results, participants, victims, or methods of commission, or otherwise are interrelated, by distinguishing characteristics and are not isolated events. So we got reliable, relatable, and relevant, right? So she's talking about being related. Okay. Now, and remember this when she keeps talking about the insufficiency and a reasonable jury. That's what she's talking about, the insufficiency and a reasonable jury. And in this area, she's attacking what was on the acquittal, right? That's what J-Bo was attacking, the insufficiency of the evidence. All right. Production of sexually explicit material. Racketeering Acts 2, Stephanie, 7, Geronda, and 10, Jane charged the defendant with sexual exploitation of a child. The government was required to prove that 1, the victim was less than 18 years old, 2, the defendant used, employed, persuaded, induced, enticed, or coerced the minor to take part in sexually explicit conduct for the purpose of producing a visual depiction of that conduct, and 3, the visual depiction was produced using materials that had been transported in interstate or foreign commerce. Case law. The defendant does not deny the evidence that he taped his sexual encounters with these 3 victims. nor does he dispute that they were minors at the time he taped them. Instead, claiming that the government had to prove that defendant did something more than just film the sexually explicit conduct. He contends that the government did not prove that he did anything to persuade, induce, entice, coerce Stephanie, Geronda, or Jane. Oh Lord, them text messages may come up. Oh no, into the sexual activity that was recorded. The defendant misstates the applicable law and the facts established at trial. Okay. A defendant can be found to have used a minor to produce child pornography if the minor serves as the subject of the illicit photograph taken by the defendant. Case law. The First Circuit in 2014, agreeing with the Second Circuit case law, as the defendant concedes, several circuits, including the Second Circuit, have held that the use element set forth in Section 2251A is satisfied when a defendant intentionally films a minor's sexually explicit conduct. Nevertheless, the defendant argues that the Second Circuit's interpretation would render the remaining terms in the statute persuade, induce, entice, coerce superfluous. But district courts are bound to follow controlling Second Circuit precedent unless that precedent is overruled or reversed. And controlling precedent meaning that is that's what's being used. That is the precedent that must be followed, right? That is what's controlling that particular um situation, right? That particular issue. So just say I say issue because it could be more. It's just more than this. They're using that precedent. They go back to that precedent to determine many cases with the same issues, the same factors. And okay, okay, case law. Okay, so the Southern District of New York, January 2020, 2009. Thus, this court is bound by the second court's holding in Soros. Okay, so she's saying that the whatever case law that Jabo submitted, that whatever's in that Second Circuit, that is the controlling authority right there. So in any event, the defendant's challenge is meritless. Section 2251A requires proof of active or coercive conduct by a defendant upon a minor. The broad interpretation of use applies when a defendant engages in active conduct. For example, if the defendant photographs or films a minor or directs the photography or filming of a minor. Case law. Reference actually. Finding that the use element was satisfied where the photographs were taken by the defendant. Reference. Finding that the use element was satisfied where the defendant directed the minor's actions. A defendant may engage in coercive conduct and persuade, induce, entice, or coerce a minor to produce child pornography, for example, by persuading a minor to take pornographic photographs of herself for himself. Let's see. Reference. Let's see. Finding that the government had not adduced sufficient evidence that certain pornographic photos taken by a minor were taken at the defendant's behest. Okay. Accordingly, the words persuade, induce, entice, or coerce in Section 2251A are not rendered meaningless by the Second Circuit's interpretation of use. In any case, the defense's argument is foreclosed by the evidence showing that the defendant engaged in persuasive and coercive conduct with Stephanie, Geronda, and Jane. They testified, as did other witnesses, about the punishments that the defendant exacted when they broke his rules and the physical and emotional manipulation they endured to meet the defendant's sexual demands. Watch her words. Watch is what she's saying, because this is not the government's words. This is not the defendant's defense words. This is the words she's using. Watch how she's captioning what happened in the trial in her own words from her own point of view. And we can see if she gonna come up with some sympathy or is she gonna throw the goddamn book. Okay, let's see. Geronda. Okay, based on this testimony, a reasonable juror could find that the defendant similarly persuaded or coerced the victims to engage in the sexually explicit conduct. Wow. The defendant also argues that the government did not prove that he acted with a purpose of producing a visual depiction and that the jury charge on this element was wrong. An examination of the jury charge itself, to which the defendant did not object, refutes that claim. The court explained that Racketeering Acts 2, 7, and 10 charged the defendant with using a minor to engage in sexually explicit conduct for the purpose of producing one or more visual depictions of such conduct. The court then quoted the relevant portion of 18 U.S.C. Section 2251A, which provides a person who employs, uses, persuades, induces, entices, or coerces any minor to engage in any sexually explicit conduct for the purpose of producing any visual depiction of that conduct shall be punished if such person knows or has a reason to know that the visual depiction will be transported in interstate or foreign commerce or mailed, if that visual depiction was produced using materials that had been mailed, shipped, or transported in interstate or foreign commerce by any means, including by computer, or if the visual depiction had actually been transported in interstate or foreign commerce or mail. Finally, the court discussed the elements that the government had to prove. To prove that the defendant committed this racketeering act, the government must prove the following three elements beyond a reasonable doubt. First, that Stephanie was under the age of 18 at the time of the acts alleged in the indictment. Second, that the defendant used, employed, persuaded, induced, or enticed Stephanie to take part in sexually explicit conduct for the purpose of producing or transmitting a visual depiction of that conduct. Third, that the visual depiction was produced using materials that had been mailed, shipped, or transported in and affecting the interstate or foreign commerce. While the government must prove that the defendant acted with the purpose of producing a sexually explicit visual depiction, the government does not need to prove that a visual depiction of sexually explicit conduct was actually produced. Let me say that again. While the government must prove that the defendant acted with the purpose of producing a sexually explicit visual depiction, the government does not need to prove that a visual depiction of sexually explicit conduct was actually produced. Meaning, oh, okay, so they had to prove that the defendant acted in like he, participated in producing a explicit visual depiction, right? So, but they don't have to prove that one was actually created, meaning like they don't have to show a tape or whatever. They're like testimony is fine. I don't know. Let's see. Let me see. I don't know how she, what she that, how she going with this. Let me see. The court's charge, viewed in its entirety, made it clear that the jurors had to determine whether the defendant's purpose was to produce a visual depiction. Accordingly, the jurors' instructions, taken as whole and viewed in light of the evidence, showed no tendency to confuse or mislead the jury as to principles of law which are applicable. Finally, the defendant maintains that the government failed to prove the interstate commerce element. Well, I gotta go for that. So she said that the claim is also unpersuasive. And remember, I told you when they write the briefs, when J-Bo was putting in her briefs, they are persuading arguments. So right here, she said that when she's talking about the interstate commerce element, she said the claim is also unpersuasive, right? Okay. Let's see, interstate video. Let's skip through that. Um, All right, let's see. Read this a little bit about Geronda. Geronda testified that the defendant made a recording of her in Illinois using an iPhone and a Canon camera. Despite this testimony, the defendant claims that the government did not establish what device, if any, was used to make these recordings, and therefore its affecting interstate commerce evidence was insufficient. However, the jury was entitled to credit Geronda's testimony about the devices and defendant's use and the government's evidence that both devices were produced out of state. Accordingly, there was sufficient evidence to convict the defendant of racketeering acts 2, 7, and 10. So far, this is just my opinion. This is just my opinion. Because we saw what J-Bo submitted. We saw what the government responded, right? But the judge is reading common sense and the applicable law to both of them, on top of both of them. And right now, and don't shoot me, this is just my legal perspective and a little bit of tad of my personal perspective. But right now, I don't see nothing that will successfully go up to an appeals and be successful. All right? Because Judge Ann, like I said, when you are invoking the laws in here, this is she got the case laws, and don't get me wrong, and I think on just one, since I've been reading, I think it's just like one time when she used the case law to to back up her decision. She's coming with mandatory law, and those are the laws that must be followed, like the Constitution and all of that. She's coming with that. Okay, so this is so right now I don't see nothing, but we're gonna keep looking. Okay. Oh, maybe we can get to the faith part with that goddamn exposure shit to the bottom herpes. Oh, wait a minute. Yeah, we'll get to it because it says it right here. Exposure to a sexually transmitted disease intent. Racketeering Acts 8A Jane, 12A Faith, and 14A Faith charged the defendant with transporting a person in interstate commerce with the intent to engage in sexual activity that exposed the person to herpes, which violated certain state criminal and public health statutes. See 18 U.S.C. Section 2421A. Whoever knowingly transports any individual in interstate or foreign commerce with the intent that such individual engage in any sexual activity for which any person can be charged with a criminal offense or attempts to do so shall be punished. The defendant claims that the government did not prove that he transported Jane or Faith with the intent of exposing her to herpes. Once again, the court charged the jury on the element of intent, a charge to which the defendant did not object. All right, let me check on y'all real quick. I'm checking on y'all real quick. Everybody good? Everybody all right? Everybody all right? I'm over here on with y'all now. Is everybody okay? Everybody follow me what I'm doing? I'm not I'm going through, I'm trying to do a couple things. I'm trying to look for her mental state, the judge's mental state right now. How is she feeling right now? Okay. We're going ahead of today's sentencing. And two, I'm looking to see where's the appellate issues. Thank you, Judge Ann. I swear, I'm gonna miss this lady. This Lennon Webber's gonna give me a heart attack. I'm gonna miss this lady. She combined both the acquittal and the new trial motion together and answered both of them. She gave us 103 pages worth of details. So, is everybody all right? I need somebody from both sides to let me know that y'all getting where I'm going. We need to figure this out. The hell, okay, I'm not gonna read any more of the hell's motherfucking comments. I just looked up at one. I'm back to lose my shit. I don't know what she talking to. That shit done took me out. So that's why I'm gonna stop. I'm not coming back over here no more. I'm gonna let chat business handle chat business. I ain't got time for y'all. That shit done took me out. I don't know what the fuck is going on or who she talking to. Because I don't know. I'm not gonna read that no more. But y'all get it. I'm just gonna assume y'all got it. No, that shit just took me out. I can't be looking up all of a sudden and shouldn't be reading some shit. Let me go mind my own goddamn business, honey. Oh, mind my own damn business. Oh, Lord. In order to establish this element, it is not necessary that the government prove that engaging in illegal sexual activity was the only purpose for crossing the state line. A person may have several different purposes or motives for such travel, and each may prompt in varying degrees the act of making the journey. Oh, okay. Wait a minute. The government must prove beyond a reasonable doubt, however, that a significant or motivating purpose of the travel across state line was the was that the defendant would engage in illegal sexual activity with the victim. In other words, that illegal activity can't have been merely incidental to the trip. Okay. Oh, okay. So she's saying that they had to prove that he took her across state line with the intention on having sex, which is kind of, if I'm not mistaken, what the Man Act states. Okay, okay. Let's see what she come up with. Let's see. Okay, the defendant maintains that the illegal sexual activity must be the dominant purpose of the travel, as opposed to merely a significant or motivating purpose. That is not the standard in this circuit. Oh, wow. The word dominant does not appear in the statutory language. See, statutory language. So that's letting you know she's using mandatory law. That's above everything. Statutory language. So this one here is not going to be an appellate issue either, in my opinion. Now, J-Bo may have a whole new set of appellate issues going forward, or she might tweak this. I don't know. But I'm just saying. Okay. Courts in this circuit have adopted the significant or motivating purpose standard. Case law. 18 U.S.C. section 2421, approving significant or motivating purpose standard. Case law. Oh, she's using United States versus Maxwell, number 20-CR330 and 2021 WL 5999410 at 8, Southern District of New York, December 19th, 2021. Ooh, they talking about Maxwell. Using significant, and Maxwell just got 20 years. Using significant or motivating purpose standard in jury charge for a violation of 18 U.S.C. section 2423A. Transportation of a minor with intent to engage in illegal sexual activity. Case law. The defendant does not challenge that the evidence at trial demonstrated he contracted genital herpes between 2000 and 2007. That his doctor, wait a minute. So we don't know when RL got the herpes. We just found out today that she got them. So we don't know if she could have been the one. I don't know. Wait a minute, oh Lord, I'm thinking out loud. Okay, that his doctor, Dr. Chris McGrath, informed him of the diagnosis, and that Dr. McGrath told him to use a condom during sexual intercourse and to let his sexual partners know of his diagnosis. Somebody could have challenged and could have said, even though, maybe the doctor didn't tell him that. Is there a record of it? Did the doctor put that in writing? Or is he relying on his memory? Maybe they could have challenged that during the trial. Nor does he appear to challenge that the evidence showed that he never used a condom during sex with Jane and Faith, and that he never told Jane or Faith that he had been diagnosed with herpes. Rather, the defendant argues that there is no evidence that defendant actions of arranging for Jane and Faith to travel to meet him was motivated by an intent to expose Jane and Faith to STDs rather than to simply have sex with them. Let's see. Because the defendant purported violation of a New York public health law prohibiting him from exposing a partner to herpes was incidental to Faith's trip rather than a motivating purpose in transporting Faith, the intent requirement of the statute cannot be sustained. Okay, wait a minute. Is she saying the defense action? Wait a minute. The plain language of 18 U.S.C. Section 2421A requires that the defendant transported Jane and Faith with the intent that they engage in sexual activity for which any person can be charged with a criminal offense. Thus, as the court instructed the jury, the government was required to prove that the defendant transported Jane and Faith with the intent of engaging in sexual activity with them, and that the intended sexual activity was illegal. The record established, and the defendant appears to concede, that his motivation in arranging for Jane and Faith to travel to meet him was to engage in sexual activity with them. In light of Jane's and Faith's testimony, as well as other witnesses' testimony about their sexual experiences with the defendant, the jury could reasonably conclude that the defendant intended to have sex with them without a condom and without informing them that he had herpes. And as explained in section IA 3(5) below, the defendant could be charged with criminal offenses for that sexual activity because he exposed Jane and Faith to genital herpes, which violated state criminal and public health statutes in existence at the time. Accordingly, the evidence was sufficient to prove the intent of the element. 4. Exposure to sexually transmitted disease, persuasion, inducement, enticement, or coercion. Racketeering Acts 8B Jane, 12B Faith, and 14B Faith charge the defendant with persuading, inducing, enticing, and coercing a person to travel in interstate commerce to engage in sexual activity that exposed the person to herpes, which violated certain state criminal and public health statutes. See 18 U.S.C. Section 2422A. Whoever knowingly persuades, induces, entices, or coerces any individual to travel in interstate or foreign commerce to engage in any sexual activity for which any person can be charged with a criminal offense or attempts to do so shall be punished. The defendant asserts that there is no evidence that he took any action to induce, persuade, entice, coerce Jane into traveling to California in April to May 2015. Instead, he says, citing text messages, the guy that told you the text messages was coming up. The text messages. Oh, damn. Citing text messages between Jane and her mother, that the record shows that Jane's mother purposefully and strategically enticed defendant with her 17-year-old daughter. Government Exhibit 233. We ain't gonna never forget that number. Government Exhibit 233. According to the defendant, he merely invited Jane to join him and she excitedly accepted. In his challenge to the evidence about Faith, he maintains that he invited a grown woman to meet him in New York and she accepted. The words persuade, induce, entice, or coerce, though not defined in the statute, are words of a common usage that have plain and ordinary meanings. Section 2242 imposes no requirement that an individual endeavor to transform or overcome the will of his intended victim. In fact, the jury need only wait a minute, hold on, wait a minute, let me see what she said. Endeavor to transform or overcome the will of his intended victim. Oh boy, she using some strong shit here, boy. She using some strong shit here. So what she's doing is she is further defining pieces of the law. Okay, she is attacking the words and the definitions and putting it in a legal sense. Okay. In fact, the jury need only consider whether the defendant intended to induce, persuade, and or entice the victim to travel to engage in sexual activity with him, regardless of whether she expressed or felt reluctance, indifference, or, for the matter, enthusiasm at the prospect of doing so. Case law. The jury was entitled to conclude from the evidence that the government proved the elements of these charges. As Jane testified, the defendant made it clear from their first meeting when she was a junior in high school that his interest in her was sexual. Thus, he persuaded her to engage in sexual contact with him, telling her he needed to ejaculate before she could audition for him. Reference. He also told Jane that he wanted to see her again and teach her a few techniques. He proposed that she meet him in Los Angeles, California, and gave her the number of assistant Cheryl Mack so that Mack could make the travel arrangements for which he paid. Similarly, it was clear that the defendant was interested in having sex with Faith when she met him after his San Antonio, Texas concert in March 2017. After the defendant gave Faith his contact information, they communicated regularly. The defendant told Faith that he loved her and invited her to meet him while he was on tour so that they could hang out, which would be fun. Reference. As he did with Jane, the defendant gave Faith Diana Copeland's number. Faith contacted Copeland, who arranged her travel to New York in May 2017. The defendant paid for the flight. Copeland also booked and the defendant paid for her trip to New York in February 2018. A reasonable jury could find that the defendant did far more than simply invite Jane and Faith to meet him, and that he persuaded, induced, or enticed Jane to travel by offering incentives, suggesting that he would teach her singing techniques. Case law. And by offering to make and pay for the necessary travel arrangements. Wow. Look here, y'all. Her mental, this judge's mental state, I don't know. I don't know. Let me come. I've got to go to the bathroom real quick, so let me come around here real quick. Just give me a minute. Give me about 2 minutes. Wow. Hold on 1 minute. eyes back. Make sure you please hit that like and share button, whatever. And I don't know, from one goddamn live to this one, I picked up 10 new subs. I don't never really talk about stuff like that, but I appreciate you. Thank you, thank you. Let me go back to my job. Okay, so let me start right over here again. A reasonable jury could find that the defendant did far more than simply invite Jane and Faith to meet him, and that he persuaded, induced, or enticed Jane to travel by offering incentives, suggesting that he would teach her singing techniques, reference, and by offering to make and pay for the necessary travel arrangements. Case law. The jury could also rationally find that the defendant persuaded, induced, and enticed Faith to travel in May 2017 by telling her that he loved her, by assuring her that the trip would be fun, and by arranging and paying for all of her travel. The fact that Jane and Faith may have been willing to or even eager to travel is not relevant. Reference. Um, it says holding that it is the defendant's intent that forms the basis for his criminal liability, not the victim's. Whoa, oh my gosh, she is going in a white type of way, in a white legal type of way. Yeah, she is going in. Okay, it says holding that it is not significant that the victims had pre-existing wishes to travel when they never acted upon those desires until the defendant made it attainable. Meaning, she's saying that it, but for the, remember I told you in law, the but for test dealing with causation, she's saying like, but for the defendant making it a thing to do, right? It's his, he's going to be out there. He's probably asked them to come. He is the one that made it possible by it even being a situation to come to. That is what she's pointing out. So she is officially calling him by method of his actions, the one that induced, enticed, persuaded, encouraged, all, even though words like that or similar in meaning were never used. She's saying just by his actions, he's the one that created the scenario in which they were able to come there and be with him. So she's saying it's him. He's criminal liable for this, his actions, so that the government proved that particular element. Number 5, exposure to a sexually transmitted disease, criminal and public health statutes. As discussed above, Racketeering Act 8, Jane and Faith 12 charged the defendant with Mann Act violations based on violations of state criminal and public health statutes, specifically New York Penal Code. We know that 2307. We already know that. And California Health and Safety Code 120290. The defendant argues that the evidence at trial was insufficient to establish a violation of the New York Public Health Code, Section 120.20 and Section 2307, is unconstitutionally vague. The defendant, okay. So when it says unconstitutionally vague, she wants the judge to define that part of the that deals with the Constitution, right, and make it applicable to what happened to this case. Says he also asserts that the government improperly charged him with an older version of the CHSC Section 120290, and in any event that the evidence did not establish a violation of CHSC Section 120290. I address these arguments in turn. Okay. NYPL Section 120.20 provides that a person is guilty of reckless endangerment in the second degree when he recklessly engages in conduct which creates a substantial risk of serious physical injury to another person. Serious physical injury is physical injury which creates a substantial risk of death or which causes death or serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. NYPL Section 10.00. The defendant argues that unprotected sex with someone who has genital herpes does not establish a substantial risk of serious physical injury because herpes is not deadly and rarely causes any serious protracted health impairments. He also claims that there is no evidence that he was contagious or had an outbreak when he was in New York. The defendants claim that herpes is not deadly and rarely causes any serious protracted health impairments, as an initial matter, ignores the entirety of the statutory definition, which includes not only causing death or creating a substantial risk of death, but also causing serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. A rational jury could find from the trial evidence, expert and otherwise, that the defendant's exposure of his victims to an incurable disease meet these definitions. All right, so she's defining them. Pay attention. Dr. Asaf Hoskins, the director of patient safety in the obstetrics and gynecology department at New York University, explained that herpes is incurable and a very contagious transmissible virus. Once the virus enters the central nervous system, it's going to stay there and it's always there. So it can reactive, and when it's reactivates, it can cause a result or an effect in other parts of the body. Herpes manifests as blisters, ulcers, uh, pustules, pust, pus, pustules, pustules, vesicles, vesicles, or whatever, causing burning, tingling, numbness, and severe pain. Outbreak can be triggered by various factors: menstruation, a common cold or cough, sunlight, and other illness such as asthma, cancer, hypertension, and diabetes, and can last anywhere from several days to several weeks. Herpes can cause other medical complications, including to the central nervous system and the brains and bloodstream. While these complications are rare, they always remain a risk for someone with herpes. The jury could reasonably find, based on Dr. Hoskins' expert testimony, that transmission of genital herpes, a permanent and incurable disease that causes recurring outbreaks with potentially life threatening complication, constitutes a serious physical injury. It says the Ninth Circuit of 1992 finding that transmission of genital herpes constituted a permanent or life threatening bodily injury. Reference, it says finding transmission of HPV genital warts constituted serious bodily injury, and collecting cases. Ooh, boy, she broke this the fuck down. Okay, so you're saying that she's saying that it meets the bodily injury. It meets that. That's what she's saying. Moreover, the defendant's victims testified about the intensity of their physical symptoms as well as the psychological effects of being saddled with an incurable sexually transmitted disease. As for the defendant's suggestion that he might not have been symptomatic, Dr. Hoskins explained that someone with herpes can transmit the virus even if he is asymptomatic, because the virus can be excreted at a time when there is no evidence that it has been reactivated. While taking medications like Valtrex, which the defendant took, can reduce the risk of transmission, there will never be a situation where there is a 100% protection. There will still be a 10 to 20% possibility of transmitting the virus, and a missed dose or a missed window of time can add to that percentage. Summarily, the defendant, Dr. Keith McGrath, not only described the symptoms of herpes, but also advised the defendant to use a condom during sex, prompting the defendant himself to acknowledge that he should use a condom when having sex. Dr. McGrath also told the defendant to warn his partners that he had herpes and repeatedly prescribed Valtrex for the defendant. Moreover, Kate and Jane contracted herpes from the defendant in the early 2000s and 2015. Given this evidence, a rational jury could find that there was a substantial risk of transmission that the defendant consciously ignored. NYPHL Section 2307 provides that any person who, knowing himself to be infected with an infectious venereal disease, has sexual intercourse with another shall be guilty of a misdemeanor. The defendant repeats the arguments he made before trial in seeking dismissal of these counts, that the statute is unconstitutionally vague. In addition, he claims that the statute does not define the term infected. The defendant concedes that his constitutional claim regarding NYPHL Section 2307 are not challenges to the sufficiency of the evidence, and thus not properly the subject of a Rule 29 motion. Remember, that was handled when the judge weighed in on those two things I did that live on. Remember about when I told you when the judge went and talked about the those text messages herself. So, and she was saying that it wouldn't be sufficient because those text messages was never raised at court, was never offered as evidence in court, as well as the second part of it, with the objection, which should have been a 12B motion. He didn't object in time, so he lost his privilege to do so. So yeah, so she addressed this. Let's see. Rule 29 only authorized motions challenging the sufficiency of the evidence presented at trial. Okay. And case law. Okay. So, knowing that the defendant's vagueness challenges to a charge in the indictment was not properly raised for a motion for judgment of acquittal pursuant to Rule 29. It says the defendant argues that the government did not prove he violated CHSC Section 120290 because the government charged defendant with a repealed version of the statute no longer in effect, and proposed jury instruction that rewrote the statute in clear violation of various constitutional provisions. He also characterizes the statute as impermissibly vague and claims there was insufficient evidence to prove the charge in any event. Each of the defendant's arguments is unavailing. The 1998 version of the CHSC Section 120290 was in effect at the time of the charged conduct in April and May of 2015. The version of the statute, which remained effective through 2017, provided, except as provided in Section 120291, or in the case of the removal of an afflicted person in a manner that least dangerous to the public health, any person afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person, and any person who willfully exposes another person afflicted with the disease to someone else is guilty of a misdemeanor. CHSC Section 120290, effective 1998, The current version of Section 120290, which did not take effect until January 1st, 2018, make it unlawful for someone to transmit an infectious or communicable disease, provided that he knows that he is afflicted with an infectious or communicable disease, acts with specific intent or to transmit that disease to another person, engages in conduct that poses substantial risk or transmission to that person, and transmit the infectious or communicable disease to the other person. CHSC Section 120290, effective 2018. Thus, while the 1998 version required, among other things, that a defendant act willfully in exposing himself to another person, the 2018 version requires that a defendant act with specific intent to transmit the disease. The indictment made it clear that the 1998 version of the Section 120290 formed the basis for the Mann Act violations charged in Racketeering Act 8A and 8B. The defendant, together with others, did knowingly and intentionally transport an individual, to wit Jane, in interstate commerce with intent that such individual engage in sexual activity for which a person can be charged with a criminal offense, to wit violations of California Health and Safety Code Section 120290, effective 1998, willful exposure of a communicable disease, in that the defendant engaged in unprotected sexual intercourse with Jane without first informing her that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances. Similarly, the court instructed the jury regarding CHSC Section 120290. It quoted the 1998 version of its Section 120290 and set forth the elements that the government was required to prove in order to establish a violation under that version. In this racketeering act, the illegal sexual activity that is charged is a violation of California law, specifically California Health and Safety Code Section 120290. And under that law, any person who is afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person shall be punished. This is what the government must prove beyond a reasonable doubt. First, that the defendant knew that he was afflicted with any contagious and infectious and communicable disease. Okay, that's one. Second, that the defendant exposed himself to Jane by engaging in unprotected sexual activity with her. Two. And third, that the defendant acted willfully. Okay, all right. And fourth, that the defendant did not inform Jane that he had a contagious, infectious, or communicable disease and obtain her consent to expose himself in these circumstances prior to engaging in the exposure. A communicable disease is any disease that was transferable through the exposure incident. With respect to the third element, I have already defined this for you. I think that's willfully, that means with knowledge and the consequences, or purposefully. It does not require that the defendant intended to expose another person to a contagious or infectious or communicable disease. Okay, so what she's saying is, so I went through that 1 through 4, right? What she's saying is that it does not require that the defendant acted with intent to infect someone. Just like if intent is more widely discussed when you're talking about cases with murder and stuff. So like when they say somebody went out there and intentionally shot somebody, you know, first degree murder, right? That was his intent to do that. She's saying that's not what is needed here to satisfy the elements. What's needed is that 1 through 4 that I just went through. So again, right now I'm not finding anything that would be successful upon appeal. if the appellate courts were to hear it. I'm just not finding. So right now, so we're looking to appeals now. Reason why? Because right now we are answering the finals of the post conviction motions. Okay, this is what we're doing now. All right. It says the court then instructed the jury about the same elements for the Mann Act coercion enticement offense charged in Racketeering Act 8B. Okay. A federal rule of criminal procedure 12, that means a rule 12 requires that certain objections to a prosecution or indictment must be raised by pretrial motion if the basis for the motion is then reasonably available to the motion can be determined without a trial on the merits. Federal Rule of Criminal Procedure 12B3. The requirement serves a number of purposes, including sparring from the court, the witnesses, and the parties, the burden and expense of a trial, and ensuring that indictments are not routinely challenged and dismissed after the jury has been seated and sworn. While a motion that the court lacks jurisdiction may be made at any time while the case is pending, a motion that asserts a defect in instituting the prosecution or a defect in the indictment must be made before trial. So remember, I told y'all there are timely filings with these motions. Okay. The basis for the motion is then reasonably available, and two, the motion can be determined without a trial on the merits. Federal Rule of Criminal Procedure 12B. All right, it's case law. Rule 12B3 includes a list of commonly raised claims under each category, including failure to state an offense and lack of specificity in an indictment, among others. If a defendant does not make a motion that falls within Rule 12B3 before trial or by the deadline set for the court for such motions, the motion is untimely and is deemed waived absent of showing of good cause. The Federal Rule of Criminal Procedure 12C3 reference, it says if the motion is untimely, the court may nonetheless entertain it if the movement shows good cause for his failure to make it prior to deadline. But defendant's claim about the California statute should have been made in a Rule 12 motion because he is claiming that there were defects in the indictment. Rule 12B3, there's a reference rejecting the defendant's post-trial constitutional challenge to indictment charging unlawful conduct with respect to methadone because the claim asserted a defect in the prosecution's institution or failure to state an offense. So I really don't have to go through all of that. It's pretty much it was untimely, it was denied. Right now, still don't see any appellate issues. All right, let's see what she says about how she feels about the response. The defendant has not adequately explained his failure to raise his current arguments about CHSC section 120290 earlier. His only justification is that the government did not apprise the defense of its intent to have the jury charged pursuant to a repealed version of the statute that it also rewrote. But the information supporting the defendant's challenges to section 120290 was reasonably available to him as early as March 12, 2020, when the superseding indictment was returned against him, making clear that the government charged the 1998 version of section 120290 rather than the 2018 version. Now, listen here. Now, maybe here. So, if she says use this as an ineffective assistance of counsel, which is it can also be an appellate issue, using this little mishap as an example, and if she makes also tack on the argument that hey, and I haven't, I'm still reading on it, so I don't know if the correct version was right on the indictment. So I don't know if that would be discussed here. I don't know if they should have used the 1998 version or the 2018 version. I don't know which one. But if I'm not mistaken, I thought that with regards to one of the something like this, Canic or the other dude put in a motion that challenges, because I think I pulled it up when Sky was on the panel. I don't know if this was the particular situation though. I don't know, but let me write that down. I'll look. Um, Motion for California, because I know it was California version, 1998 or 2018. Maybe here. All right. It says on July 2nd, 2021, little more than a month before the trial, the government submitted proposed jury instructions, which also altered the defendant that the charge was based on the 1998 version of the statute. Okay, this is what I was just talking about. So she's going to cover it. I think, yeah, this is what I was talking about. Okay, which also alerted the defendant that the charge was based on the 1998 version of the statute. The information the defendant cites for his vagueness argument was also available to him before trial. The indictment currently at issue is the same document defendant reviewed before trial. So if that document is vague now, then it was vague then, which is when the defendant should have voiced his concerns. Because that motion I was talking about, those exchanges back and forth about which one should be in the one that they should be on the jury instructions, right? This is what I'm talking about. In fact, the defendant raised vagueness arguments about NYPHL section 2307 in his pretrial motion to dismiss. Let me read this footnote right here. Okay, defense counsel pointed out, here we go. Defense counsel pointed out that the jury instructions included an older version of the statute in September 18, 2021 letter. Let me write that down so I don't have to look all over for it. Thank you, Judge Ann. I like Judge Ann. I'm going to miss you. 2021. Okay, letter copy the text of the current version of the statute and asked the court to require the government to clarify whether the claim is that the defendant intentionally exposed others, which is required under the current version of section 120290, or that he willfully exposed others, which is required under the older version. 219. Okay, but as explained above, the defense was on notice far earlier that the defendant was charged with violating the statute in existence when he committed the predicate act. So right there is when. So that right, this is ineffective right here. That this whole thing, this part right here, I don't know. So let me go back and read this. It says, in fact, the defendant raised vagueness arguments about NYPHL section 2307 in his pretrial motion to dismiss and to strike. He could have made similar challenges to CHSC section 120290, which he did not. Whoa. See, this falls back on the defense team. So hey, this might be one thing that they got going. It says the defendant has not established good cause for his failure to challenge CHSC section 120290 in a Rule 12 motion. Accordingly, not only are the defendant's constitutional claims about CHSC section 120290 beyond the scope of a Rule 29 motion, they are also untimely and as a result waived. So if it's beyond the scope, so she's saying, hold on, I've got to do some work on that. Unconstitutional. It's beyond the scope of it. Okay. All right. I'm going to check that out. Okay, so in any event, the defendant's arguments are without merit. He challenges the 1998 version of the statute on as applied and facial grounds, arguing that it fails to provide adequate definitions that put individuals with any chronic and potentially contagious diseases on notice of what amounts to criminal conduct, including communicable diseases that are not sexually transmitted. He theorizes that anyone with herpes simplex 1, also known as cold sores, who kisses another person without disclosing that they have herpes simplex 1 is guilty of a misdemeanor. The defendant is foreclosed from challenging CHSC section 120290 for vagueness, either on as applied or a facial basis. The Due Process Clause of the 14th Amendment requires that every criminal statute, one, give the person of ordinary intelligence a reasonable opportunity to know what is prohibited, and two, provide explicit standards for those who apply the statute. Case law. A criminal statute is unconstitutionally vague in violation of. Okay, wait a minute. Let me read this before I go there. Let me read this footnote. I address the defendant's constitutional claims in an excess of caution because even though he conceded that they did not challenge the sufficiency of the evidence and may not constitute a proper Rule 29 issue, he suggested that the court must first decide whether the jury was properly instructed pursuant to the applicable law before it can decide the Rule 29 question. That is, whether there was sufficient proof at trial. Okay. There's nothing there. It says, okay, a criminal statute is unconstitutionally vague in violation of due process if it fails to give ordinary people fair notice or is so standardless that it invites arbitrary enforcement. Even if there is ambiguity as the margins of what conduct is prohibited under the statute, Dickinson 604, that's the reference. It is clear to an ordinary person that CHSC section 120290 would prohibit the defendant's conduct having unprotected sex knowing he had herpes and without informing his partner. Moreover, an as applied vagueness challenge supported by a law potential for arbitrary enforcement must fail if the enforcement at issue is consistent with the core concerns underlining the statute. The defendant conduct falls within section 120290's clear core protecting the public from the spread of infectious venereal diseases. It says April 25th, 2013, noting the transmission of an infectious disease is the type of injury the statute was designed to prevent, according to the defendant, cannot show the statute is vague as applied to him. Okay, so she rejected that too. Okay. Nor is the special challenge available to us. So the challenge is not available outside the first American. The challenge permitted by the second this be valid or with law infringes upon another constitutional protected right. Let me read this because this is constitutional. So this is something that could go up. All right. Nor is a facial challenge available to the defendant. Outside of the First Amendment context, facial challenges are permitted only when no set of circumstances exists under which the law would be valid. Uh, Case law, it says, or where the law infringes upon another constitutionally protected right. Morales does suggest that facial challenges are permissible outside of the First Amendment context, but that case only permitted such a challenge in the presence of a constitutionally protected right. The defendant does not pre, pre, premi- Jesus premise his vagueness challenges to Section 120290 on the violation of some other constitutionally protected right, let alone a First Amendment right. As a result, the defendant cannot challenge Section 120290 on facial grounds unless he can show there is no set of circumstances under which the statute would be valid. Wow. As explained above, Section 120290 clearly prescribes his conduct and is not vague as applied to him, noting that Salerno effectively eliminates facial challenges outside of the First Amendment context that could not also be brought as an applied challenge, since any law that is unconstitutional in every set of circumstances is also necessarily unconstitutional when applied to any plaintiff. Oh, wow. Outside the First Amendment context, we look to whether the statute is vague as applied to the particular facts at issue, whether the indictment improperly challenged the 1998 version of CH that okay presents a closer question. The conduct relevant to this question is the Mann Act conduct, transporting Jane in interstate commerce with the intent to engage in sexual activity criminalized by state law, and coercing or enticing her to travel in interstate commerce to engage in sexual activity criminalized by state law. Case law. The defendant argues that the government had no authority to charge him with a statute that was repealed or inoperative at the time of the prosecution. The government responds that in the racketeering context, the relevant consideration is whether the predicate racketeering act was a violation of the relevant state or federal law at the time that the underlying conduct was committed. I'm trying to get to the Constitution, trying to see where she ends up with the Constitution with this. So, okay, so the RICO statute defines racketeering activity, among other things, certain acts chargeable under state law and certain acts indictable under federal law. Neither party cites a case that addresses the issue in this case, whether the underlying sexual act must violate state law at the time of the defendant committed them or at the time of the indictment. Case law. So it says the Third Circuit in 1978 provides at least persuasive support for the notion that the indictment properly charged the defendant with violating a state law that was in effect at the time he committed the conduct. Okay. In Davis, the Third Circuit held that the defendant's violation of a state bribery statute could serve as a RICO predicate, despite the fact that the state's law statute of limitations had expired by the time of the RICO indictment. According to Davis, the time barred bribery properly served as a RICO predicate because the acts were chargeable under the state law at the time they were committed. In so ruling, the court defined chargeable under state law in 18 U.S.C. section 1961 1A as chargeable under state law at the time the offense was committed, rejecting the defendant's interpretation that chargeable under state law meant presently chargeable under state law. Whoa. So, applying Davis and holding that for statute of limitation purposes, the relevant question is whether a charge of participating in the enterprise and not whether particular acts of racketeering could still be charged under applicable state or federal law. Although Davis addressed a slightly different question, whether time barred state acts could nevertheless constitute racketeering acts in a RICO indictment, its reasoning is persuasive in the context of this case because the defendant's 2015 conduct was chargeable under state law at the time of the offense was committed. Davis 576 F second at 106 and 67, and thus indictable under the Mann Act at the time he engaged in the conduct. The government appropriately charged the 1998 version of the CHSC section 120290. She's trying to answer my question. Give me 1 minute. She's been answering my question. Finally, the defendant argues that even if the elements of the statutes were, as the government alleged, insufficient evidence existed to sustain the charge, the defendant makes the same claims he makes about Racketeering Act 12 faith, that there was no evidence that he was contagious, infected, or had the capacity to transmit herpes when he had sexual contact with Jane in 2015, and that the government cannot show that he acted willfully with knowledge of the consequences. These claims, the only claims about this conduct are cognizable cognizable in a Rule 29 motion, have no merit. Oh wow. Jane testified that she contracted genital herpes after the defendant had unprotected sex with her in the summer 2015. She experienced discomfort in her pelvis and her lower abdomen and saw a doctor in August 2015 when her symptoms got worse to the point where she could not physically even walk. The doctor diagnosed her with herpes and prescribed her medication. When the defendant told her that she could have gotten that from anyone, she responded that she had been intimate only with him. Jane's medical record also reflects that the defendant was her only sex partner. Wow, wait a minute. Oh, they're saying that, oh, I don't know if they're sex partner at the time or sex partner ever. I don't know. So Jane's testimony, as well as the evidence that the defendant infected multiple other victims with herpes, provided a reasonable basis for the jury to conclude that the defendant was infected with herpes when he had sex with Jane in 2015. And I lost my space. And that his act in exposing Jane to the disease was willful and purposeful. The word willfully, when applied to the intent with which an act is done or omitted, implies simply a purpose or willingness to commit the act or make the omission referred to. It does not require an intent to violate the law or to injure another or to acquire any advantage. Whoa, 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 whoa. So that again is the elements is not requiring that him just saying I'm going to go out and have an intent to break the law. by infecting someone with purpose with herpes. Wow. I'm still trying to see if there's some kind of constitutional thing. Um, Maybe she had already answered it or whatever. When I was reading when she was going through the 1998 and 2018 version. I'm trying to see. Let me see. Or to injure another, or to acquire any advantage. It was equally reasonable for the jury to find that the defendant acted with the knowledge of the consequences. Okay. And that he knew that unprotected sexual contact with Jane would expose her to herpes. The defendant knew he had herpes. His doctor warned him of the risk and directed him to alert his sexual partners of his condition. Wow. So I'm still don't know how she's going to fall if it's constitutional, right? As far as what J-Bo could do, you know, determining whether he should have been indicted under the 1998 or the other year, 2018, I believe. So it says, let me see if this is something sexual activity with minors. Right? Hold on. Okay. This is about the interstate commerce part of it. As far as, let me see. Yeah, minors outside the male interstate commerce beyond persuasion. And any sexual person charged with criminal offense should be punished. A person knowingly transported an individual interstate commerce then intended to engage in any sexual activity. Person can be charged with criminal offense could be punished. Okay, hold on. Let me see. Because I don't want to go over repetitive stuff. According to interstate cell phones. Okay, so she's saying, as far as the interstate commerce, transportation of a minor across state lines, she's saying, according to the interstate cell phone calls, satisfy the first element of that section of 2422B. This says, see, the defendant next between use of exchange during a 6-month period. Okay, with regards to Geronda, she says that there's evidence that was sufficient to show that the defendant used interstate commerce to persuade, induce, or entice Geronda. And then she says, okay, and I'll read this part. A rational jury could also find that the defendant did persuade, induce, or entice Geronda to engage in sexual conduct. Words like persuade, induce, and entice are all words of causation. Remember, I used to talk to y'all all the time about causation, right? Um, R. Kelly is the cause, his action is the effect. The but for test. But for R. Kelly's action, none of this would have happened. As a way to say it. So that's when she speaks of causation. Let's see. Okay. So it says 11th Circuit 2020 holding that induce means to stimulate the occurrence of or to cause. The evidence from multiple witnesses, victims, and members of the defendant's enterprise established that the defendant implemented strict rules in or out of his home, that he expected that his victims and employees obey his commands, and that he exacted punishments for perceived violations. A rational juror could infer from the defendant's directions to Geronda to leave his house and go to his tour bus that he induced or coerced her into having sex with the defendant and Juice. Hmm? Okay, wait a minute. Okay, reference. Okay. Find an inducement where the jury could have inferred that the defendant made a request for an additional video of a minor with the intent to cause or bring about the creation of that video. Okay, remember, it's the intent to cause or bring about the creation, but it doesn't necessarily mean that they have to prove that one was created. Equally unpersuasive is the defendant's argument that no reasonable juror could conclude that the defendant knew that Geronda was 16 years old. Oh, this is going to be good. When they allegedly engaged in sexual activity between May 2009 and January 2010. Geronda testified that she told the defendant for the first time that they engaged in sexual activity that she was 16 years old and showed him her identification. The jury was entitled to credit her testimony and find that the defendant did not believe that Geronda was 17 years old when he had sex with her. In Racketeering Act 9, the government charged the defendant with Mann Act violations based on violations of California Penal Code, which provides that any person who engages in an act of unlawful sexual intercourse with a minor who is more than 3 years younger than the perpetrator is guilty, where unlawful sexual intercourse is an act of sexual intercourse accomplished with a person who is not the spouse or perpetrator if the person is a minor and a minor is a person under the age of 18 years. The defendant acknowledges Jane's testimony that she told the defendant her true age, 17 years old, in 2015. Now, have they? Okay, they didn't jump to Jane Doe number 5, I think, in 2015, right? But argues that the evidence was nevertheless insufficient because the record does not reflect precisely when she told the defendant her age. Jane testified that she told the defendant she was 17 years old in Chicago when summer ended and she had to go back to school for her senior year in high school. She returned to Florida but moved back to Chicago and then joined the defendant on his tour. Moreover, the letter from Jane's parent authorizes Juice's mother to be Jane's guardian until she turned 18 years old, dated September 19, 2015. And Suzette Mayweather testified that the defendant and his entourage left New York for California on September 29, 2015. Based on this evidence, a rational juror could conclude that the defendant knew Jane was less than 18 years old prior to their California trip. And you see how that permission slip played a part all along as we talked about, because we said who with the who's 18 years old needs a permission slip from their parents, right? Nobody. So it says, with respect to Racketeering Act 9B, 18 U.S.C. Let's see. The defendant maintains that there is no evidence that he took any action to induce, persuade, entice, coerce Jane to travel to California between September and October 2015. As explained previously, the government did not need to prove that the defendant overcame Jane's resistance or that Jane did not want to travel. The evidence showed that the defendant arranged for Jane to enroll in virtual schooling and for Juice's mother to serve as her legal guardian. The defendant paid for Jane to travel back to Chicago. She subsequently traveled with the defendant from city to city for his shows. Accordingly, a reasonable jury can find that the defendant persuaded, coerced, induced, or enticed Jane to travel to California. Here, she is referencing the text messages, although she had already deemed them, insufficient. So it shouldn't be really, it wasn't sufficient because it was never introduced at trial. So it's not on the record to be used. She is referencing that because she's specifically talking about the the um the challenge is that it's not that the element and the law is not that Jane has to, it has to be proven that Jane did the enticing, the coercion, whatever, or that she did not want to travel. So that means that he, like she was saying, oh, I don't want to go, and then he persuaded her to go and whatever. The judge is saying that's not the element, that's not the law, and that's not the intentions as stated in the law. So that's what she's addressing. So, and remember, J-Bo used those text messages for the enticement, enticement, persuasion, coercion, and inducement. All right. Um, okay, back on the phone call enticement. All right, the interstate stuff. I'm not going into that because she's saying the reasonable juror can um, would be satisfied for what they use to prove interstate commerce. So that's the cell phones or whatever they use, the computers. The defendant argues that the purpose of travel. Okay, let's read this. With respects to Racketeering Act 9D, 18 U.S.C. Section 2423A, the defendant argues that his purpose in traveling to California was to perform, and he arranged for his girlfriend to go with him, and any sexual activity was purely incidental to the purpose of the trip. Jane testified that she and the defendant had sex almost every day in the summer of 2015 and that they had sexual contact while traveling on tour. The jury was entitled to rely on Jane's testimony as well as testimony from the defendant's other sexual partners and conclude that sexual activity was the defendant's significant or motivating purpose when he arranged Jane's travel with him. So the judge is saying that sex was a big, not the main reason, but it was a reason to have her there because the fact that she said they had sex almost every day. All right, I think somebody was talking about forced labor. Let's see. Let me see if we want to do that. Okay, defendant forced labor. Okay, well, we'll do forced labor. Forced labor. All right. Racketeering Act 6, Geronda. 11, Jane, and 13, Faith, charged the defendant with forced labor. 18 U.S.C. Section 1589A. Whoever knowingly provides or obtains the labor or services of a person, one by means of force, threats of force, physical restraint, or threats of physical restraint, or that person or another person. Two, by means of serious harm or threats of serious harm to that person or another person. Three, by means of the abuse or threatened abuse of law or legal process. Or four, by means of any scheme, plan, pattern intended to cause the person to believe that if the person did not perform such labor or services, that person or another person would suffer serious harm or physical restraint shall be punished. To convict the defendant of forced labor, the government must prove: one, the defendant obtained the labor or services of another person; two, the defendant did so, A, through threats of serious harm or physical strength against that person or any other person; or B, through a scheme, plan, or pattern intended to cause the person to believe that non-performance would result in serious harm to or physical restraint against that person or any person. And number three, the defendant acted knowingly. Case law. Serious harm is defined as any harm, whether physical or non physical, including psychological, financial, or reputational harm that is sufficiently serious under all of the surrounding circumstances to compel a reasonable person of the same background and in the same circumstances to perform or continue performing labor or services in order to avoid incurring that harm. Okay, so I don't have to go through the attacks. I just want to get to um okay, and show the evidence. So let me see what she says. In short, the evidence supporting the charges was more than sufficient to establish the defendant's guilt, and his attacks on that proof are nothing more than disagreements with the jury's resolution of evidence. Nevertheless, I address each claim in turn. So she's already saying, I don't have to go through that. She's already saying that they proved, what was the charge? They proved the forced labor on those three girls, ladies. Um, I'll have to go through that. Trying to see. James defended only the issues to the system, but she did not testify that the defense force. I know she resisted. Can't defend the text and prove that right to like 13 court. Trying to get to how she's thinking. Let's see. That Amina Pause took pictures. Okay. So let me see what she says here. This is still about the forced labor situation. It says the jurors were entitled to conclude from this evidence that the defendant obtained oral sex from Faith by means of an implied threat of force or pattern of conduct that was intended to cause her to believe that non-performance would result in serious harm. So she buys into that. Let me see. As explained, because okay, so she said other counts. The defendant challenges the sufficiency of the evidence as to counts 2 through 9, as noted throughout this order. These counts correspond to certain predicate acts, as explained above. Because there is sufficient evidence establishing each predicate act, there is also sufficient evidence of counts 2 through 9. All right, now she gets on the motion for new trial. Let me see, what page is this? Okay, because favorite circuit. Okay. All right, now we finna get to the motion of new trial. This is where I thought that the defense had their better shot to getting something, and all the other attorneys that came out said this would be the. So let's see what the judge said. Ineffective assistance of counsel Verdier. The defendant attacks the performance of his trial lawyers during the Verdier process, finding fault with 8 of the 12 regular jurors and with one alternate juror who did not deliberate. The defendant claimed that his counsel did not do a meaningful Verdier of potential jurors and should have probed more by asking additional questions and challenging certain jurors as unqualified. This argument fails for multiple reasons. Uh, a defendant claiming that his lawyer was ineffective must meet the two-pronged test articulated in Strickland versus Washington. One, that the counsel's reputation fell below an objective standard of reasonableness, and two, that there is a reasonable probability that but for the counsel's unprofessional errors, the result of the proceeding would have been different. There's a reference. Under the first prong of Strickland, a defendant must Okay, we know that. Went over that 1,000 times. Let me see. I'm trying to get what they rule is with that surviving R. Kelly stuff. Let me see if she says something about that. Okay. Second guess counsels. Okay, well, let me read from here because she ties herself into this. Let's see. In addition, the council must make judicious, use of preemptory challenges as well as compare jurors with one another in an effort to select the best jurors for his client. So, remember, she was asking for the juror. She was asking for the prosecutors, I believe, the prosecutors to submit the jurors that got dismissed, all the questions, whatever, for the jurors that got dismissed and the jurors that were seated, how they answered the same questions or something similar like that. So remember, I said back then, I said she must be did ask for that so she can do a comparison to say, well, if a person that was dismissed answered the question the same way as the person that stayed, what was the difference or whatever, right? So let's see what she came up with if she goes that way. So let me see. Okay, so for these reasons, courts are loath to second guess the decisions of counsel during jury selection. Case law. It is not the role of the court to second guess counsel's reasonable strategic decisions at jury selection, especially considering that counsel is strongly presumed to have rendered adequate assistance and made all significant decisions in the exercise of reasonable professional judgment. Counsel is accorded particular deference when conducting voir dire, and attorneys' actions during voir dire are considered to be matters of trial strategy. It's a review of counsel's performance is highly deferential in any case, but the case for deference is even greater when counsel is evaluating credibility. To satisfy the prejudice prong of Strickland, the petitioner must establish a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Okay, I don't need to read all that because I went through that. Yeah. Okay, the benchmark for judging a claim payments must be with counsel. Okay. A defendant alleging ineffective assistance during voir dire must show that the juror was actually biased against him. In other words, in order to show prejudice. Case law. In order to establish that trial counsel was ineffective for failing to challenge a prospective juror on voir dire, actual bias must be established. Actual bias is the bias in fact, or the existence of a state of mind that leads to an inference that the person will not act with entire impartiality. Case law. Actual bias can be found where the juror admits partially or where partially partiality, can be inferred from the jurors for their answers. So remember, I had a lengthy conversation with Keller one day on those sub questions and stuff. So by the questions, right? And I said if they ask, even if they've watched Surviving R. Kelly, they know about R. Kelly, whatever his allegations from the past. If they said they can be and be non-biased and base a decision just on the evidence, then they could be seated. And remember that they have like three challenges for cause, and the defense they have 10 preemptory challenge where they can just dismiss someone without giving them a reason. So, but you got a whole jury panel there. So I mean pool. So you don't want to waste all your challenges. So let's see. The defendant falls short of this exacting standard. The record shows that the lawyer who conducted the voir dire, a lawyer with years of criminal trial experience in both state and federal courts, participated actively in the process. Before the court questioned the prospective jurors, counsel went through the questionnaires and made decisions about which jurors were appropriate to question and which to challenge for cause. Once the oral voir dire began, counsel demonstrated a thorough knowledge of the information in questionnaires and frequently asked the court to pose additional questions to prospective juror. Oh boy. Oh boy. So she had a active role in this. Oh boy. He successfully challenged prospective jurors for cause over the government's objections and made vast challenges to the government's use of preemptory challenges. He also exercised preemptory challenges when he deemed it appropriate. This active participation in voir dire indicates that any decisions to challenge or not to challenge jurors were made as part of a reasonable trial strategy rather than as a result of counsel's failure to provide effective assistance. So she is saying that when they were picking the jurors and based on what she saw happen, the it looked more like a strategy than the counsel being ineffective. And also, we got to see if she addresses R. Kelly's declaration too, because remember he wrote a declaration with regards to this. Let's see. All right, the WDNY was May 21st, 2020, finding that a decision to seat jurors was part of a reasonable strategic approach to selecting a jury where the counsel actively participated in voir dire and asserted a Baston challenge. Not only does the record thoroughly refute the defendant's argument on ineffectiveness, it also is clear that the defendant has not established that any juror was actually biased, let alone all nine about whom the defendant complains. Huh? Wait a minute. Hold on. Let me scratch my back real quick. The defendant claims, nevertheless, the counsel was obligated to challenge any juror who had watched Surviving R. Kelly, a documentary about the defendant, or who had heard something about the defendant's prior criminal prosecution. This is what I just said. But qualified jurors need not be totally ignorant of the facts and issues involved, and it is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Each juror confirmed his or her ability to render a fair, impartial verdict, which was what I said, right? But she's the judge. She ain't my bitch ass. Okay. Moreover, none of the challenges the defendant asserts on appeal would have warranted granting a challenge for cause in excess of caution. However, I addressed the defendant's complaints about individual jurors. Wait a minute, none challenge asserts on appeal would have warranted granting a challenge. Oh, okay. Okay, General 3, let me see. She goes through all the jurors. All the jurors. So we already got her answer. But this is just the jurors that she that J-Bo had an issue with. So we already know the answer. We don't have to go through all of those jurors, but it would be fun to go through them and see what was the issue. Not tonight. Okay, B. Conflict of interest. Now this is Nicole Blank Becker. Hold on, let me come check on y'all real quick. See what we doing. Y'all still here? And I look up, I see a whole bunch of comments from Dale. I refuse to read them. Yeah. Oh man. Hey, do y'all mind? Can y'all give me a couple of minutes? Can I go run and get something to eat real quick if y'all don't mind? Please, please, please. No, I'm back with my rib. What's going on, y'all? Yeah, if you talk about children and mothers, no children and mothers. The hell should know. She should know the thing. Well, let me take a little bite of this and rib. I'm so damn hungry. The footnote, which okay, Queen, everybody, the footnote where? Hold on, let me see. Uh, oh, he got a damn Queen. Everything you catch everything. She addressed the damn declaration. Okay, all right, here goes. Y'all handle chat business. No kids and mamas and stuff like that Y'all play nice. All right. In an effort to demonstrate that he did not acquiesce in the council's strategic decisions, the defendant submits a declaration in which he claims that counsel did not consult with him, that he expressed concerns that certain jurors watched Surviving R. Kelly, simultaneously claiming that he did not know that he had seen the show. Wait a minute, simultaneously claiming that he did not know he had seen the show. Hold on. The show, and that he was merely a bystander during the voir dire. The defendant raised none of these concerns during jury selection and does not include a declaration from any of the four lawyers who represented him. In any event, the counsel's decisions were well within the realm of sound trial strategy, and the defendant has not come close to establishing bias. Whoa. Oh boy. Judge Ann is answering everything my bitch ass thought of. As I said, she talked to, I can't did the goddamn declaration. Judge Ann said, bitch, I got you. I got it right in his footnote. Thank you, Queen, everybody. Okay. Remember, footnotes are important. Shout out to Miss Margaret, who is what cancer free. Woohoo! My old paralegal, remember she taught us? Read them up on footnotes. Okay, so here go the conflict of interest. All right. See, I probably have to read all of this. The defendant argues that he is entitled to a new trial because he was denied his Sixth Amendment constitutional guarantee of conflict-free counsel. This claim has no merit. Oh boy. The court held a custodial hearing after the government advised the court that Ms. Blank Becker might have a conflict. The defendant does not claim that the hearing was deficient, nor does he deny that the court appointed competent counsel to advise the defendant that the evidence established that the defendant was capable of making a knowing and intelligent waiver of, or that he waived the conflict. Oh, waiving a conflict. Okay, all right. The defendant also does not deny that as part of that waiver, he acknowledged that he was giving up the right to have Ms. Blank Becker represent him without a conflict of interest, and that he could not later claim that his lawyer, Ms. Blank Becker, wasn't an effective lawyer because she had these conflicts or potential conflicts. Well, potential conflicts, she had that in there. Nevertheless, the defendant now asserts that the conflict that he explicitly waived, Ms. Blank Becker's possible attorney-client relationship with Jane, was not waivable. According to the defendant, the supposedly unwaivable per se conflict was Ms. Becker's communication about the case with the government's key witness, notwithstanding that the witness had her own counsel and did not consent to the communications, which subjected Ms. Blank Becker to accusations of misconduct. Ooh, that's what it was about. The right to counsel under the Sixth Amendment encompasses a correlative right to representation that is free from conflicts of interest. When a district court is sufficiently apprised of even a possibility of a conflict of interest, the court was here as the court was here, it must investigate the facts and details of attorney's interest to determine whether the attorney is in fact suffers from an actual conflict, a potential conflict, or no genuine conflict at all. Case law. If the court finds that defense counsel has a genuine conflict, it has to determine whether the conflict is so severe as to require the attorney's disqualification or whether it is a lesser conflict that can be waived in a cursio hearing. Case law. The defendant may knowingly and intelligently waive his right to conflict-free counsel in most cases where a defendant's attorney has a conflict. Only in rare cases is an attorney conflict unwaivable. Case law. It's a Second Circuit 2003, recognizing that attorney's conflict is unwaivable if no rational defendant would have knowingly and intelligently desired that attorney's representation. The Second Circuit has found per se conflicts of interest only where the trial counsel is not authorized to practice law or where the trial counsel is implicated in the same or closely related criminal conduct for which the defendant is on trial. A per se conflict exists only where trial counsel is not authorized to practice law or is implicated in the very crime for which the client is on trial. The fact that Ms. Blank Becker contact with the witness might have subjected her to claims of professional misconduct, a subject that the court explored thoroughly at the cursio hearing, does not make the conflict unwaivable. As explained in Fulton, the per se rule applies when an attorney is implicated in the crimes of his or her client, since in that event, the attorney cannot be free from fear that a vigorous defense should lead the prosecutor on the trial judge to discover evidence of an attorney's own wrongdoing. But the per se rule does not apply anytime a court learns that an attorney may have committed a crime. The attorney's alleged criminal activity must be sufficiently related to the charged crimes to create a real possibility that the attorney's vigorous defense of her client will be compromised. As the court explained at the cursio hearing, Ms. Blank Becker's communications with Jane in 2019, knowing she was represented by another attorney, could have been an ethical violation. But that's neither a crime nor sufficiently related to the crimes with which the defendant was charged. RICO, Mann Act violations committed in the 2018 and earlier to constitute a per se conflict. Next, the defendant asserts that Ms. Blank Becker suffered from an actual conflict of interest that could not be waived because she had previously represented Jane and that the conflict was imputed to her trial partners. The defendant cites United States versus Stein, in which the court held that an attorney conflicts are ordinarily imputed to his firm based on the presumption that associated attorneys share client confidences. But the lawyers in the that case were part of the same small tax firm. The lawyers in this case were not partners. They did not work for the same firm. And there is no evidence that Ms. Blank Becker shared any confidential information with the other lawyers. No presumption of confidence sharing arises between a law firm that received confidential information and a separate firm serving as co counsel with it. All right, let me read this footnote. The defendant reference to Ms. Blank Becker's simultaneous representation of defendant and government witness Jane is inaccurate. As the court found, Jane never formally retained Ms. Blank Becker, and nothing in the record suggests that she represented Jane at the time of the trial. So remember, I was telling y'all that they may a a go through a test to see if, and I call it a test. That's basically what it is when you start talking law talk, to see if there was a attorney client rep an attorney client. Well, I can't get this out. An attorney client relationship ever established between Nicole or Jane Doe, right? Number 5. So that's one thing down right there. So I don't. Let's see if this would be something that would be an appellate, issue. But let's see. I don't know. Okay, it says Second Circuit of 1987. It says finding that conflict was not imputed to co-counsel where the evidence did not indicate a general partnership relationship between the attorneys extending beyond the representation of the petitioner herself. Sorry about that, y'all. Okay, the defendant was represented by 4 lawyers, 3 of whom had no conflict or potential conflict. Ms. Blank Becker's conflict related only to Jane, whom Ms. Blank Becker did not cross-examine. Mr. Canning, lead trial counsel, cross-examined Jane. In short, to the extent that Ms. Blank Becker had an actual conflict of interest, that conflict was clearly waivable. Whenever a defense attorney has previously represented an important government witness who testifies against her client, the possibility of a conflict of interest exists. Lesser conflicts, such as an attorney's representation of 2 or more defendants or her prior representation of a trial witness, are generally waivable. The Second Circuit in 2010 affirming district court's refusal to order a new trial based on lead defense counsel's conflict of interest arising from his previous representation of a cooperating witness for the government, where the defendant waived the conflict. So that's it. That's all she said about that. Hold on. Okay. So that's it. She's saying that the conflict the conflict is generally the conflict is waivable, and there was no attorney-client relationship. So, and Canick did not. I mean that she did not cross-examine Jane Doe number 5, and that there was no communications that with regarding to the case that was ever given over to Jane Doe number 5. So that was the situation with that. So it was not that she already solved it by the Curcio. She went through and told you that it wasn't even a matter that should have been brought, because there was no conflict at this point. So that's what it is. So whether or not he had, he so actually the prosecution, I know they said something about his right to have his own his own the lawyer of his choice comes first over having a lawyer without conflict, right? That's when the judge would have to step in and then remove the lawyer if there is a conflict that's unwaverable, right? She she's not even that was the prosecutor said. And of course we know what J-Bo's argument was as well. So the judge said something totally different. So it had nothing to do with him, Ann Donnelly resolving this during the Curcio. Her answer is just, what I summed up. All right, now the evidentiary rulings. This is the Ann Donnelly portion of it. These are the issues with regards to Ann Donnelly, and this is also a reason for an appellate, for an appellate application, right? Let's see what Ann Donnelly say. Let me see. Okay, the defendant also challenges the court's evidentiary rulings. And the court means the judge. And claims that the court permitted irrelevant and excessive bad character evidence that was minimally probative and unduly prejudicial. Specifically, the defendant challenges the court's admission of one, Angela's testimony that she saw the defendant perform oral sex on Aaliyah. Number two, evidence that the defendant exposed other women to herpes. Number three, testimony by Addie, Alexis, Kate, Anna, Angela, Lewis, and Alex. And four, the defendant's video recording of sexual activity involving the defendants, Alex, Dominique, and Anna. The defendant also contends that his lawyers did not adequately challenge the introduction of some of this evidence. As explained below, none of the defendant's arguments has any merit, let alone warrant a new trial. Let me get another little bite, y'all. Another little bite. I don't eat while I talk. So let me see. I'm coming, y'all. I'm coming. Okay, let's see. In this area, this was mainly where she would really be overruling herself. Okay. Under the federal rules of evidence, evidence is admissible only if it's relevant. Federal rules of evidence 402, evidence is relevant if it has a tendency to make a fact more or less probable than it would be without the evidence, and the fact of its consequence in determining the action. Federal Rules of Evidence 401. Under Rule 403, the evidence that is relevant may nevertheless be excluded if its probative value is substantially outweighed by the danger of one or more of its following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Federal Rules Evidence 403. And applying Rule 403, the court conscientiously balances the proffered evidence probative value with the risk of enumerated dangers. Okay, so I don't really have to go through that. Okay, let me see what she says about herself. Okay, now I'm just reading a little part of what she says. Okay, she says Angela's testimony was relevant to the bribery charge in Racketeering Act 1 and was not barred by Rule 404B. In particular, evidence that the defendant had a sexual relationship with Aaliyah was evidence of his motive in connection with the bribery case. The government asserted that the defendant concocted the plan to marry Aaliyah, which could only be accompanied by bribing the officials, in order to keep secret his sexual relationship with the young teenager. Thus, testimony from a witness who actually saw them having sex was relevant, nor was the testimony's probative value substantially outweighed by a risk of unfair prejudice, as evidence as the defendant's sexual contact with Aaliyah was no more inflammatory than the charged offenses. Evidence shall be excluded as unfairly prejudicial when it is more inflammatory than the charged crime. All right. The defendant contends that the government established the defendant's motive for bribery in other ways, including Demetrius Smith's testimony that defendant mentioned that Aaliyah was in trouble and thought she was pregnant. But Smith, like Angela, did not see the defendant having sexual contact with Aaliyah while she was a minor. Oh, but Smith, unlike Angela, okay. As the government points out, Angela's testimony was particularly probative in the view of the defense counsel's refusal to concede that the defendant and Aaliyah engaged in sexual activity before their marriage. So, therefore, Angela's testimony was admissible. All right. Evidence that the defendant exposed other women to herpes. We went through that extensively. Okay, so according to the defendant, this evidence was unsupported by other theories of admissibility and therefore amounted to rank propensity evidence. The defendant is wrong. Right? I told you propensity evidence can only be allowed to show like the motive, intent, things of that nature, right? If it's showing just to show somebody that has the propensity to commit a certain crime, then it's generally not allowed. It's not allowed, actually. So let me see. All right. Geronda testified that she contracted genital herpes in 2019 or 2010 and told the defendant about it. Similarly, Kate testified that she contracted genital herpes and told the defendant that she believed he gave her a sexually transmitted disease. Evidence that Geronda and Kate conveyed this information to the defendant was probative of the defendant's knowledge, and he had herpes, which the government was required to establish beyond a reasonable doubt to prove Racketeering Acts 8, 12, and 14, as well as counts 6 through 9. So, right here, so we answer that question. She's saying that based in her courtroom, based, what she heard or whatever, that they proved that he had knowledge that he had herpes. Okay. Contrary to the defendant's assertions, the record does not reflect that the defendant conceded that he had genital herpes, knew he had the disease, or knowingly exposed others to the disease. During the August 3rd, 2021 pretrial conference, the court asked the defense if it would stipulate that the defendant knew he had herpes. The defense did not stipulate, meaning that they did not agree to submit something to stating in the record that he had herpes. And let's see, it says I don't know to what extent the defense has considered stipulating to some of this evidence. This is regarding the transmission of herpes. The government is saying that this is relevant to show the defendant's knowledge of the condition, But I think some of this, if there is a stipulation about that, it becomes less relevant. Moreover, the defendant suggested in cross-examining cross-examining doctors McGrath and Hoskins that the defendant did not have herpes because no one had given him a blood test. Kate and Deronda's testimony was relevant to show that the defendant knew he had herpes, which established his knowledge for the charged offenses involving Jane and Faith. Okay, so remember a long time ago, I said if someone, just say the doctor, just say he was never told by the doctor he had herpes, right? Just say that. But just say one of the people, because remember we was having that discussion about, how we know who gave it to him and all of that. Well, when someone informs them that they have herpes, and especially say, well, I think you gave it to me, now you've been noticed. Now you've been put on notice. And if anybody you have sex with and you don't tell them that you have herpes or you may have herpes or whatever, or obtain their consent, then you become criminally liable for exposing somebody to herpes, especially if they get it. So, damn, I'll put this in my mouth. Hold on. So what she's saying is, when Kate and Deronda told him that they had herpes, that established his knowledge that he had herpes. So when he turned around and allegedly gave it to Jane and Faith, you can't you can't say now, when you get to the Jane and Faith, when you get to there, back down to them, you can't say like you ain't know nothing about it, because they've established that Kate and Deronda told you via their testimony, and I guess maybe records or whatever. I don't know what was submitted at court. But yeah, Judge Ann is off the chain, baby, with it. Okay, the testimony was relevant even if counsel had stipulated, as it corroborated other victims' testimony, that the defendant's practice was to have unprotected sex without disclosing his sexually transmitted disease. The testimony was thus admissible as probative of one of the enterprise's means and methods charged in the indictment, in particular, engaging in and facilitating sexual activity without disclosing a sexually transmitted disease the defendant had contracted. The defendant faults trial counsel for not challenging the excessive amount of herpes evidence from numerous other witnesses, but does not cite any specific piece of herpes evidence to which the trial counsel failed to make an objection. Oh. Okay. To the extent that he means to complain about testimony discussed above, there were multiple grounds supporting the testimony's admissibility under the federal rules of evidence. Thus, trial counsel's decision not to object to the evidence was not objectively unreasonable. Nor can the defendant claim that the result of the proceeding would have been any different if counsel had objected, since the evidence was admissible. What she's pretty much saying is that even if they would objected to some of the evidence that came in, most likely they would have been doing it just for fun, because she would have went ahead and allowed her to answer, as well as the evidence that they submitted. The other evidence they submitted was admissible with regards to the herpes. So she would have overruled their objection. So Okay, let's see. Testimony about Addie, Alex, Kate, Anna, Angela, Lewis, Alex. The defendant also argues that the court improperly allowed testimony by 7 additional witnesses. Okay, Addie, Alex, Kate, Anna, Angela, Lewis, and Alex to testify about graphic, uncharged bad act evidence. The defendant challenges this witness testimony as cumulative and unduly prejudicial and faults trial counsel for not competently objecting to it. The defendant's argument does not warrant relief under Rule 33. Okay. As explained at the trial and in my earlier written decision, the testimony of Addie, Alex, Kate, Anna, Angela, Lewis, and Alex was admissible to show either the existence of the enterprise, a purpose, and relationship among those associated with the enterprise, or the enterprise's means and methods as charged in the indictment. Whoa, okay. That might be a little switch and bait there, Judge Ann. Hold on. Because do we know? I mean, I wasn't in there and I don't know the transcripts like that. Do we know what they actually testified? When did they come in and what did they testify to? We can go back and look at that motion in limine. I think it was dated either 7/23 or somewhere, or maybe August the 2nd, one of those. And to see what did they actually testify to. Because if they are establishing the relationships among those associated with the enterprise, did they testify that they were either part of that enterprise, what that octopus was, or were they associated with someone with that octopus that was on that octopus? Was it that? Or, okay, I do remember some of them saying how like they got numbers from people that worked for R. Kelly or whatever. And that's not limited to the people on the octopus. I'm just giving you that as an idea. So from the people that, was supposed to work for R. Kelly or be associated, in fact, right, with them with regards to the RICO. So they may be okay with that. Addie's testimony about the defendant's sexual contact with her when she was a minor was evidence of one of the purposes of the enterprise to recruit, okay, answer my question, to recruit girls or have sex with the defendant. So that's what she's saying. Okay. You see what they're saying, like the purposes of the enterprise, which are the people, that's to recruit the girls and stuff. So what I was saying just a little bit ago about where they associated with members that was in that octopus or people that work for R. Kelly, like to get the numbers and shit like that. Okay. And thus probative of the existence of the enterprise and the way it operated. Oh boy. So I don't really have to go through all that. Evidence of purposes, methods. Okay, yeah. In addition, okay, let's see what she says here. In addition, I balanced the probative value of each piece of evidence against the potential for undue prejudice as required by Rule 403 and concluded that the proffered testimony was not unduly prejudicial. Okay. Let me see in these footnotes. Okay, so let me read this by these herpes. It says, counsel asked Dr. McGrath, is it fair to say that say, Dr. McGrath, that from your experience in treating Mr. Kelly sitting here in court today, you cannot say that 100% he has herpes. In a similar effort to suggest that the defendant might not have herpes, the defense counsel asked Dr. Hoskins if a blood test was the best way to determine if a person has herpes. Okay. Okay, let me read about this. It says the court properly allowed Kate's testimony about contracting herpes from the defendant for the reasons explained above. Accordingly, the court need not to repeat that rationale here. It is unclear why the defendant cites Alex's testimony as unfairly prejudicial because while she testified that she had sex with the defendant when she was in her teens, it was not before she was 18. Um, defendant is okay, wait a minute. Okay. Okay. Let me read this. Oh, it got some say video exhibits. Hold on, let me get to that. It says defendant argues that his lawyers did not make adequate objections to the introduction of bad act evidence at trial, that they affirmatively introduced other prior bad act evidence. As a threshold matter, since the evidence was properly admitted, counsel cannot be ineffective, even if they did not challenge the evidence at all. In any event, counsel did object that the defense had not been given timely notice of the government's intent to offer the evidence, and argued that the court should exclude the testimony regardless of the timeless issue. Trial counsel filed a supplemental brief on August 6, 2001, objecting to the admission of uncharged crime evidence under Rule 44B and Rule 43. In addition, in August 26, 2021, letter filed under seal, the defendant's lawyers moved to preclude the testimony of Addy and Lewis. Under these circumstances, there is simply no basis to find that trial counsel's representation fell outside the wide range of reasonable professional assistance. And remember, I did a live on what the higher courts look at, and that is a high bar to prove that someone isn't ineffective. Let me read this footnote. It says the victim's testimony about the defendant's uncharged acts was also admissible under Rule 413 because it was relevant to the charged sexual assault of Geronda Jane Fay. In criminal case in which defendant is accused of sexual assault, the court may admit evidence that the defendant committed any other sexual assault so long as the evidence is relevant. Okay. Let me eat this real quick. You see that? There go video exhibits. Give me a minute. Okay. Video exhibits. The defendant also disagrees with the court's decision to admit certain graphic video evidence. Government exhibits 341 through 343 depict sexual encounters between Alex, Dominique, and the defendant. In one of these recordings, the defendant guided Dominique's head while she performed oral sex on Alex. In Government Exhibits 328A, the defendant spanked Anna, who was naked, while she walked back and forth, crying and robotically the repeating that she was a slut and stupid. In Government Exhibit 329A, a 9-minute recording of which the jury saw only a few minutes, Anna spread feces on her naked body and called the defendant daddy. Which one was Anna? The defendant objects that this evidence was not relevant to any means and methods of the enterprise since there was no enterprise, and whatever probative value it had was substantially outweighed by its prejudicial effect. And I'm tripping because now wait a minute. Okay, that's slick, J-Bo. You're saying that it was not relevant to the means and method because there was no enterprise. Okay. All right, let me read some more. The video depictions of sexual activity between Alex Dominique and the defendant were properly admitted into evidence. First, the evidence showed the control that the defendant exerted over his victims and therefore demonstrated the means and methods of the enterprise alleged in the indictment. The defendant directed Alex and Dominique, whom Alex described as zombie-ish, how to have sex, what to do with each other, and how to react. Second, the videos were direct evidence of one of the purposes of the enterprise to recruit women and girls to engage in sexual activity with the defendant as well as to produce pornography. Third, the video evidence corroborated in Alex's testimony and provided support for testimony of other victims, including Jane and Lewis, that the defendant required them to have sexual contact with others, which the defendant filmed. The videos were admissible under Rule 403 because they were relevant and probative and not unduly prejudicial. The exhibits corroborated the trial testimony and were no more inflammatory than the offenses with which the defendant was charged. The video recording of the defendant punishing Anna, while graphic and disturbing, was properly admitted under Rule 404B, and its probative value was not substantially outweighed by any risk of unfair prejudice. The means and method of the enterprise included, among other things, demanding absolute commitment to the defendant and not tolerating dissent, to of obtaining sensitive information about sexual partners and members and associates of the enterprise to maintain control over them, and creating embarrassing and degrading videos of sexual partners to maintain control over them. The video recording of Anna, Government Exhibit 328A, was direct evidence of the enterprise and the way it operated. It was an embarrassing and degrading video which the defendant created and demonstrated the force he used to control his victims. Oh, she mad. Spanking them and ordering them to say degrading things about themselves. Oh wow, she's mad. The video also corroborated Anna's testimony as well as Jane and Geronda's about the ways the defendant punished them for breaking his rules. The second video exhibit, also explicit and horrifying. Oh wow, she pissed. Y'all wait a minute. Y'all have to give me a minute. I gotta eat a little bit more. I don't know about this here. Hold on, y'all. Just give me a minute. Food done got cold. These are her words. She that lady need to prepare her client. These are her words. Hers. Lord have mercy. I'm so glad I'm semi-retired of shit, basically retired, because my nerves too bad. I got too much of a soft heart sometimes with this shit here. She need to prepare her client. These are her words. Her. The second exhibit, video exhibit, also explicit and horrifying, was similarly admissible as evidence of the ways in which the defendant used humiliation and punishment to control his victims. The recording supported Anna's testimony that the defendant made her do oh my God, dehumanize, dehumanizing, humanizing, humanizing, humiliating acts involving bodily fluids. The video also corroborated Jane's testimony that the defendant punished her by forcing to eat feces and spread it on her body. So she's already, to me, she's already not going to buy into that scat sex thing that they was talking about in the mitigating report. She's already gone down and rejected that. Because the recording served these legitimate purposes, they were appropriately admitted. The video recordings were awful, but the crimes charged were awful, involving 1, sexual exploitation of minors, 2, forced labor, the defendant's violent degrading assault on Geronda to force her to perform oral sex on him, and the defendant's threats, including the presence of gun, to force faith into oral sex, 3, kidnapping, and 4, aggravated criminal sexual abuse. Therefore, the court's decision to admit the foregoing video recordings does not warrant a new trial. Finally, the defendant faults trial counsel for challenging the videos belatedly. Excuse me. As explained above, the evidence was admissible, so counsel could have not been ineffective, even if making a belated objection constituted ineffective assistance of counsel. So, meaning belatedly means that they're saying that she objected because it was too late. But as explained above, the evidence was admissible. So, the ineffective assistance of counsel, it just wouldn't have made, it just wouldn't have mattered. You see what I'm saying? She's saying that the evidence was admissible. So just because the counsel refused to object to it, it wouldn't have mattered anyway because she was going to allow it in. You understand what I'm saying? I had to get that together, but I'm choked up how this lady's talking this strong on this shit. Wait a minute. In any event, counsel moved in limine to exclude the evidence involving Alex and Dominic as highly inflammatory, needlessly cumulative, and because the probative value, if any, of the material is outweighed by the danger of unfair prejudice to the defendant. The defense initially objected to the admission of the government's Exhibit 329A, objected to planned government's Exhibit 328A, and successfully challenged the admissibility of another video of Joy. In sum, the court's evidentiary ruling was appropriate exercises of discretion. All right, let me check some of these things real quick. Okay. Nor the counsel ineffective because he opened the door to evidence that the defendant was the subject of a criminal case in Illinois, for the simple reason that jury never heard that evidence. So let me see what is that referencing 57? Hold on, y'all, real quick. Referencing 57. Okay. What are they talking about? nor the was counsel ineffective because he opened the door to evidence that the defendant was subject in a criminal case in Illinois for the simple reason the jury never did hear that evidence. Let's see, was there another one? Okay. The government played on a very short portion of the video. We're going to play a very limited snippets and did not play it again during the summation. I'm not going to play Government Exhibit 329A for you again. So I guess they're saying that because they didn't play the entire thing, they only played snippets and they didn't play it over and over, that didn't make that particular evidence prejudicial, right? It wouldn't have prejudiced the defendant by making him seem, more guilty than he actually, allegedly is. So, what else? And it says, for those reasons, the defendant motions for a judgment of acquittal and for a new trial are denied. Oh boy. Well, come on around here and see still here. So, oh Lord. Okay, I'm gonna start reading the hell's comments. I'm gonna stop doing that. I'm back around here. I see you. So, y'all. Oh man. I'm not. I'm scared to. I'm scared to read it, honey. I'm not. I don't get in chat business. But so listen, y'all. I couldn't find any real good appellate reason. The only thing that may be an issue is, that to see if he was indicted under the right version of the law, the 1998. I don't know if that's the California or the New York, but 1998 to 2000 or 2018. I'm not sure. I think it's gonna come down to, did they use the right one when the crime was committed versus when the crime was actually charged or found. I'm not sure. It's too late to go through that. But baby, so it seems like she kind of got her mind made up. Well, I mean, we already know that, of course, what, but I'm trying to say that I don't know what of that mitigation report would she accept. I think she would probably accept about his history and maybe how that had an effect on him or what have you. But if she comes up with any premeditation, I don't know about that. She didn't say nothing about premeditation throughout the document, but I think I've got just about all of the places where I feel like she expressed herself in there. Not just, I didn't read all stuff we already know about the case. I didn't read all that. That was just rehashing. That she gave a damn detailed summation of what the hell went down. In the case, she gave like a little miniature goddamn transcript. Yeah, that appeal, We on post conviction, relief. Okay. So she already killed this. We looking to the appeals. Can't find nothing. Unless J-Bo J-Bo can go through and find some more stuff. It doesn't have to be the stuff she brought up on the post-conviction motion. No, it doesn't have to be that. She can go through and find some more stuff. And she can also bring up the same issues as well. Some of them. All depend, some of them. Yeah, she showed, you're right, Elvira. I ain't gonna sugarcoat no shit for you because y'all don't be like, Andrew, you said he was gonna get 2 years. I ain't say that. So she did address this shit. Oh, let me see if I can tell when she had this ready. Oh, she dated on the 29th, but I'm beginning to think she had this ready earlier than the 29th. Oh, Lord, I ain't dropped this link to let nobody come tell me about nothing. If y'all want to, I know it's late, but I'll be here, a few seconds. This crazy. Mm-hmm. I don't know, y'all. I don't know. I dropped the link, honey. I don't know. Live out where you at. We want to know what to think, think. Jojo, wake up. I want to know what to think, think. Dana, stop snoring. I want to know what to think, think. Anybody hit the link? I want to know what you think. Skylight hit the link. I'm calling out the names of the people I know hits the links. We want to know what to think, think. Mm, 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 mm. What time is the hearing tomorrow? The sentencing, I mean, what time? Does anybody remember what time? I don't know why my nerve bad.
Link.
Courtney Love.
What's happening, Peaches?
What's good with it, girl? What's good with it? Peaches on
What's
the job,
good?
girl. What's
What's
going
good
on?
with it? I've been with you on and off all day. We been at this shit for about 15, 16 hours.
Okay.
I've been in here.
Okay, girl.
I've been in here.
Girl, yes,
I
honey.
just
I'm
want
like,
to
Lord.
and show my support for our channel.
Thank you, sweet. Thank you. I appreciate you. I appreciate all y'all
Mm,
hanging on in there with a girl.
yeah, we
Girl
hanging.
had to knock it out, put it in the books.
Yeah.
Yes, child. So what you think, girl? What you think?
Mm.
You don't know?
What I'm thinking is we gonna know at 10:15 tomorrow.
That's what time it's gonna be?
I think 10 o'clock, something like that. Something like that. What I'm thinking, that was a heavy load
Mm-hmm.
today. But what I'm thinking and what I'm hoping, for okay, let me get my thoughts together. What
You
what I'm
got it,
think
baby.
what I'm thinking is I hope that well I follow a lot of channels and I follow the news and I hope and I'm thinking that the media really gets this out here that in the documents, if I comprehend clearly, that through psychiatric evaluation, he was not deemed a pedophile. Not all that other bullshit is a non-motherfucking factor to me, because I said that I was going to stick in this fight. Because a lot of times, I think, just my opinion, I think people lose path and when we come on these panels, we don't make it clear on why we in the fight, how we got into the fight, because we the supporters, we the ones in the chat, because I don't have
Mm-hmm.
no channel. But I'm it's gonna be an emotional day for the Kale supporters and for the Kale's fans to really get our thoughts together on this,
Yeah.
because nobody forced me to get in it. I heard JoJo last night, and this is what I took on, and I also took this on in my personal life, because you got to understand the perspective of this outside of YouTube. People talk about this.
Mm-hmm.
I work every day. People talk about this, and it's a whole demographic of people that still believe in this man's innocence when it
Right.
comes to child pedophilia in the New York case. And I think my thoughts are, uh, I had to piggyback on some things that I have discussed over in other chats, that we focusing on this New York case and this New York sentencing tomorrow. And that was a really good letter from Joycelyn. I had a lot of respect and admiration. I was not there. That is her fiance. And those words, those letters were very touching.
Right.
Yeah.
You know. So did you hear much of the reading from earlier?
Yeah. Yeah, I heard when you read the psychologist. What
Yeah, yeah, yeah.
I
Cause
heard.
I put two little polls on the community board. Cause I mean I found that stuff to be. I mean I know nothing about a lot of that stuff. You know, I just do the paper part of it.
Mm-hmm.
And some of the stuff that was disclosed and to to find out
Yeah. Yeah,
that that J-Bo was trying to keep that report from the public. Sorry, y'all. Y'all know how my bathroom was ways. I be out of breath, child. Yeah, this is in the room, but shit, that's what we're sold on the side of the bed, outside the room. Shit. But
yeah, I'm saying, yeah, I heard you when when she didn't, and that's what I'm saying about what I want to focus on. I heard a lot of the reading today.
mm,
And
thank you.
you know, hey, they still didn't say that man was no pedophile. They said he had no sexual desire to have sex with children. So now when we get into this age, we can bicker backwards and forwards with that. You know, um, we got to go with the law.
Right. Now that was the mitigation expert report, right?
Yeah.
So yeah, that's going to be um, pro R. Kelly. But as you see where I read the psychology portion, I mean not psychology, the prosecutor's portion of it, I don't believe they address whether or not he's being, you know, called a pedophile in there, but they do have some issues with the mitigation expert going along with what R. Kelly said
Hmm.
versus the evidence and stuff, that was introduced at the trial.
Well, we finally got a chance to hear him speak.
Right,
Let's comprehend
right,
this right. You know what I'm saying? We finally
right.
got a chance to let him speak.
And I don't understand why now the prosecution knows that that's the defense mitigation expert. Not
Mm.
it ain't working for them. So of course it's going to be pro R. Kelly, and they know that hearsay and all of that on both of their parts is allowed in those reports. So
Well,
I'm not sure
it,
what the argument
it
was.
should,
Why?
yeah, neither, but it should be for our Kelly, because if it was me, I'm fighting for my life. I'm
Yeah,
and it is what I said it is. And whatever he
yeah,
said to the people, that's what he said to the
to the
people.
people. Right, right. And
You
I was
can't
what
in no room, because I don't know the experience of other people, in the chat, but you can't get up in the room with a psychiatrist and lay it down, and not unless you the grand manipulator of them all. And I doubt that very seriously. I doubt this man walked the streets for freely in Chicago. And the way, and you have a lot of people that come in here, um and I ain't coming in here to start nothing because I don't know nobody in here, but I do read the chat and I do listen to the panel, and you gotta understand when we say or we not direct, we just conversing here.
yeah,
So I say, when we have when there's panels in here, and you listen to them, a lot of them have a street perspective on this.
yeah,
And a lot of the men that I listen to, they have a code that they go by, and then here we go with this other side with the law. So I thought that those were some beautiful letters. I thought that was a real touching letter that Keith wrote.
yeah,
It's bittersweet, and we heard him speak. Until we hear him speak again, that's when we gonna know.
right.
Cause you gotta remember, he didn't say nothing.
Yeah, he didn't take the stand. So, there was a way and that y'all were able to see. I mean, those the people that, and I guess on both sides would want to hear what he has to say. But there was a way that he could speak and give his side of it,
Mm-hmm.
and he didn't take the stand or whatever. So, I mean that part of the what she submitted today. That's what I already told y'all. That part two, that's gonna be the meat and potatoes. That's what we needed. And she kept fucking around. And I was getting
Yeah,
mad, girl. Give me the report. Give me the stuff so I can read it.
yeah,
I'm
cause
nosy child.
oh,
I ain't mind my own business.
you
But
know,
that was going to be the meat and potatoes of what they, because it was a lot of stuff I didn't know.
yeah, it was a lot of stuff we didn't know, and it's a lot of stuff. Yeah. Mm-hmm. I can agree on that, because
Yeah,
I step back for a minute, but
yeah,
I still have to say it. This man does not deserve no lifetime sentence for this shit. The shit done got too goddamn confusing for me. But this, I don't, I just don't believe that this warrants no lifetime sentence. I don't, I don't. And I do know how the law, shit, they hang pedophiles before murderers. Murderers get out on bond, all kind of shit. And this trial just behooved me, and it was interesting, it was intriguing, and I'm glad that I took part in it. I can say
Right.
that myself. And you don't hear people saying that. All you hear them is, fuck you, bitch, this motherfucker. We want a perspective on this, because this can
Mm,
happen to anybody. And the way that they doing this shit nowadays, all these boys getting indicted, they using social media for this. And I
yeah.
think that this case and these subsequent uh federal indictments, like with that rap group down there in Atlanta, this stuff sets precedents. And I don't think
Mm,
that people was really understanding the words that the intelligent people was using in these conversations.
right. Right.
In these
Right.
conversations.
That's a good way to put that. And let me say this before people go off to sleep. Shout out. Shout out. Man, I want to shout everybody out. Shout outs to those channels who was diligently bringing information with regards to the case and not bullshit. Now, whether you read the paperwork or whether you assembled panels or you brought this information with regards to this R. Kelly would depend, don't matter what side you're on. Because
Mm-hmm.
you got people that devoted their channels into bringing bullshit, you know.
Yeah.
I
Yeah.
mean, just messy bullshit or whatever. And just really like, I mean, why are you here? Like, what the fuck for?
Mm.
They have nothing to contribute, nothing out of goddamn thing. And they know it. That's why they contribute bullshit. Shit else you can do. You're
Yeah.
useless.
And it was, it is, I really like this channel. I like a lot of other channels too, where
Yeah.
we speak and say whatever we want to say without somebody drag you through the mud, because you could just tell, by listening to people, the type, and the type of experiences that they've had or haven't had, or how they dealt with them, because this mental illness came out full fledged over
Yeah.
here. You know what I'm saying?
Yes.
This mental illness came on up out of there.
Came on up like you were like, what the hell is
and
going
and
on?
it's funny. It's funny that I mentioned that. When I first started going into the chats, I said this. I said, this right here, somebody gonna either, I'm telling you the truth of what I said. And this before the burning down the cars. I'm talking about, this is before all this add on. Because you got to remember, in the beginning, the initial indictment, they kept adding and adding and adding and adding and adding. So, the content got, intense. And I
Mm,
said, it's going to be some people ended up going to jail, losing their mind, or
mm-hmm.
committing suicide. And you ain't got to even commit suicide fatally. Because
Yeah.
I'm quite honest, I'm quite sure some people, you know, uh, get honest, how, with all this rhetoric in the sector, because we had supporters, we had fans, we had the sector, we had who shot you and who ain't who, and a lot of times that stuff couldn't be addressed because you had to respect people's chats, and you couldn't call names. But we already know what went down. We already know how this went down. And I thank you for letting me come in, and we'll see, what the judge sends him, because we had already said longer time. Well, I did when I was in the chat. I had already said long time ago, I accepted the guilty verdict. Did I agree with it? Hell no. Hell no. And I still stand on that. Whether whoever is listening to me think I'm all over the place, freak hells. freak
Mm.
hells, because I mean, I understand the shit that came out in that, but thotterism is real. You got to
Oh Lord.
understand the theology of this. And if you don't, I feel sorry for you. Raise your kids, raise your girls right. Cause ain't no way in the hell nobody's kids should have been running around chasing after a 50-year-old man. But see, some of this shit ain't even, and then the other perception of it. Some of this stuff, he was in his 20s. He was in his 20s. You so I had to debunk that lie, like saying that this man was running around as a 50-year-old man chasing little kids. And I just didn't see that. I just didn't see that. And I know it's late. I know can't nobody come up on the panel. But I stayed up on and off with you, Peaches. I was with I
Well, I sure appreciate and thank to the people that be coming through that
yeah,
be wanting to listen to
you
the what the hell is going on and not no bullshit. I
I
mean,
know
that's to
bullshit.
all the channels that don't deliver bullshit. Cause I mean, some of these people here is just slow. They can't do much.
And want to
They
teach.
could do. Some people could do like one hour. And they be, honey, they brain be fried, honey. They be like, mm-mm. I'm like, baby, all you doing is reading.
Baby, you roll with this. I called in today. I took one for the home team. But I was with y'all last night. And I was in Skylight, but I had to come on out of there because see, I had to get the information. And see, I really actually, didn't take no notes or anything like that. Cause see,
Mm.
I'm the type of person I watch this shit 2, 3 times so I can understand what the fuck is really going on.
What's
And I
going
understand,
on? Right.
I'm the replay gang, cause I'm a replay some shit because I work every day. But I'm a replay so I can get an understanding, so I can express how I feel. And I feel like
Hmm.
this is a travesty for the king of R&B, and nobody can ever take that title from him. And that's facts. That's how I feel. He will
Wow.
forever be the king of R&B. Infamous. See, cause see, now we gotta wait for this next trial. And sometimes it's predictable, and sometimes this shit ain't predictable because of the things that we don't know. You
Right.
feel what I'm saying, Angie?
Right.
And it's gonna be some documentaries coming out. Oh, you already know the BBC, the PBC, and all of them. They following this, and I just hope that the media, don't depict this man, you know, as some type of crazed monster.
Now you know what? While I'm sitting up here, because J Bo, not to cut you off or
Go
change
ahead.
the subject, I'm just thinking about so I can knock this out too. So I have to go back and do this. Um, J Bo put in her motion and limited. It came on through. Honey, them people in Chicago working my damn nerves how they do stuff. So I want to see because she jumped on um Milton Brown's a certain portion of their motion and limiting. She was I mean that's good. I mean I know that lady is cheesing like hell. She's like J-Bo jumped on my motion of limiting and I'm a PD. Oh hell no, I've been cheesing like a motherfucker. Like, huh? You mean to tell me you adopting some of my work as yours? Are you
Shit.
serious?
Don't Milton Brown got a public defender?
Yeah, and
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 she
and J
called
Bo,
and she called with it.
she is.
She
When I
called
when
with it.
I was reading, I was saying this lady goddamn good.
She
And to
called
see,
with
let me see what part she jumped on, so I can read what part she jumped on. She say, okay, she says, separately, defendant joins defendant Brown's motion and limine as to arguments 2 through 5. So let me pull that up real quick. If y'all don't mind, y'all want to roll? Y'all, let's see, Milton Brown. 2 through 5, y'all. Remember that 2 through 5 because I would. I may forget. Milton Brown. Okay. His motion is limited 2 through 5.
Shit, man, Brown said he don't want to be no part of none of that.
Right.
None of that. Cause he don't know what the hell they talking about. That's what it sounds like Milton Brown lawyer saying to me.
Yes, the government. Milton Brown. Okay, his motion is limited.
Yeah, let me see.
So she's jumping on arguments too. I mean, that's the shit. That's a big portion of the goddamn. What I say, y'all 2 through 5, right? Good night, SM. 2 through 5. That's exactly what that is. Is that it? Okay. So arguments 2 through 5 is goddamn. Is that the whole paper? Hold on. I mean, is she jumping on the whole? Hold on. You got to be kidding me. You gonna make me fall the fuck out. Hold on. Hold on. Please tell me. Hold on. Oh my goodness. Y'all. J-Bo. Hey, J-Bo got a little blackie on her, baby. J-Bo like shit. Okay, check this out. Now this Milton Brown motion unlimited. Okay, this is one. Okay, that's the first one. J-Bo is jumping on the two. Two is on the next page. Two. Now this is a 17-page document. This is page 3. This is question 2. J-Bo want 2 all the way to the end of the man document. She done jumped on this. J-Bo like, I'm phoning it in, baby.
J-Bo, J-Bo, the coldest I done seen. She
Yeah.
nigga,
So
niggas
J-Bo like, baby,
get money
that
up.
lady, I know that lady grinning. I know that lady happy as hell. She like, hell yeah.
Shit,
J-Bo want to be on my motion?
mm, she jumping at all angles, and
Yeah,
you
J-Bo
got
like it's
you got to give it to J-Bo. J-Bo came in. J-Bo came in. Shout out to J-Bo. And what
y'all.
I had missed y'all for a minute, right?
Mhm.
Angie,
Yeah. Uh-huh.
I had stopped listening to you for a minute. And I jumped back in, and y'all nicknamed her J-Bo. I'd like to holler.
Yeah.
Y'all,
Her name is Jennifer
yeah,
Bonjean. So, and
Jennifer
I was like,
D.
you got Jennifer Lopez. So I like, shit, J-Bo. J-Lo and J-Bo. Yes. Y'all. I mean, she done adopted the
Ooh,
latest work, honey. 2 through 5. That's the majority of the goddamn Milton's Brown Motion Unlimited.
mm-mm.
What? Boy, this is straight him. Ah, yes.
Well, you know,
I
this your
right.
expertise.
Mm-mm-mm. Sometimes I say, who was that night? I was explaining that now Daryl McDavid can go on take a plea, go on get out the way, and that way, let um R. Kelly, just with the co-defendants, just since they having such a problem, just gonna get out the way. And I don't know who it was. It was somebody. I said, "Tell my hell, tell his ass to get out the way and take a plea to get the hell out the way, or something like that." Honey, I'll holler. Because sometimes I look up at them goddamn comments y'all be saying, I be back and cracking the hell up. I said, these people crazy as hell.
Do too. I do too.
Mm-hmm.
So, but you can't. As far as my stance, I came on here because this is our channel, and I had to let it be known
Yes,
for
our channel, baby. That's why I named it.
for the people in the back. free R. Kelly all day. And then and what kills me is this shit was a comprehensive type of thing. As far as really actually following a trial. Because I've never done that before. I would just, court TV, this, that, and the third, get it, listen to the news. But when this shit hit the goddamn fan, 4 years ago, I was like, God damn, what the fuck? What the fuck is this shit here to take
Hmm.
down and to shake down?
It's crazy.
I'm gonna catch a panel where I could come up in here, you know, because I done had conversations with Keller, and that and
Yeah.
the third or whatever, and it's all respect, from my end. You know,
You're
I,
right.
I've never disrespected anybody, so I hope that if I do pop, because I will pop in. I don't want no pop off.
Yeah.
I don't want no pop off because respectively and sincerely, Courtney Love. Don't get it twisted. Free cash.
Right, honey.
Yeah,
Girl. Well,
yes,
see, I
it is.
think I think both Levi's. I know JoJo goddamn he been tripping as it getting closer to his damn
Yeah,
date. So I think both of them was pretty much just
yeah,
they nerves bad. I'm like I don't know
yeah,
what the hell was going on.
yeah. They
You
know.
gonna tell me you talking about I cut for Levi. I was like, well, you ain't like it last night. Like you wanted to cut him.
They we. I was like, hold on,
Yeah, hold on. I was like, what the hell is
hold
going on?
on. I said,
And
wait.
I cut for Levi. Like, it seemed like you wanted to cut him. And I
Mm,
still cut for Levi. I was shit. Sound like you wanted to cut his ass.
yeah, but now, as
Basically.
far as take me back. Take me slow. As far as the 10 to 17 years on the table, that's what J Bo got on the table, right?
Mm-mm.
Okay.
So the precinct report, PSR, right?
Uh-huh.
When they calculated, it came out to a level 43, which is life.
Mm,
When J Bo submitted her proposal, she said that the benchmark should be between 14 and 17 and a half years. That should be the benchmark. She is asking for 10 years. That's what she's asking for.
okay.
The government is asking for at least 25 plus.
Mm,
Right.
hmm
So, yeah.
I say 10 years because I had already said even before um the trial got started, we ain't dumb over here. Some of
Mhm.
us over here at Kill supporters, we understand. And I felt like, all of it was overkill and charge him accordingly. Because I don't know, maybe I'm not comprehending this right. But as far as the herpes allegation, shit, I thought Greenberg said that was a misdemeanor.
Well, here's the thing, right? With people, and I know I hear this because, Jeff will always say, well, they should have charged him with us. What they're going to do
Mm,
is they're going to charge you with what they can actually qualify you. Not that this is what they're supposed to do. Not nothing more or nothing less. And if they can convict you, that kind of substantiates that you were charged correct.
hmm
They can make an argument for that because the elements were there and all of that.
Yeah.
Now, what he was
I, I,
talking about,
I
the statutory and state things or whatever. Yeah, but I mean, those stuff has, most of that stuff has statute of limitation, except when it comes to crimes involving minors, right?
uh-huh.
Yeah. Other than that,
Me and you had this conversation before. Oh, girl, you done took me to school so scandalous up here. I'd be like, don't be doing that. That might have a criminal element to it. Because remember, Remember we was talking, we was like, shit, you motherfucking around be committing crimes, don't even know you commit crimes. Where they got the
Yes.
dog twisted and mangled up. Oh hell no.
Yes.
This
You be
is
committing crime, don't
bullshit.
even know it.
You don't even
And I
know.
don't be knowing it. Hey,
Mm,
what?
That's why they ass from down there on Maccabee with shit. Fuck around and get caught up in a motherfucking raid. Shit, you don't know
Right.
where the fuck you going, who the fuck leading you, all this misconception, all this deception and shit, you hearing this shit, all these lies. I mean, I understand, but it was too many lies told to me. Some of it I just I shit. I ain't the one, with that. Oh well, will you see it on black and white? I see it on black and white when it come to money. That's the way I see that. Black and white when it come to money.
Hmm.
Now you said it cost this much. You see what I'm saying? I don't see this. If anybody feeling what I'm saying.
Hmm.
But we gonna know. We gonna know. We gonna know. We gonna know tomorrow.
Yeah.
Yeah, we gonna and then we on to the next battle because we have to for the Kel supporters, that's still in the chat. We had to stay strong. In the words of some other person, we have to stay diligent. And when you ready to throw in the towel, throw in the towel. And I will say this, you know, uh, I always said that once they show me a kid, I'm out. They ain't show me no kids. They ain't showed me no kids. I ain't seen no kids. All I seen was thoughts.
Oh no,
I know
not
you don't like. I
ah.
know you don't like that word, but that's
Well,
all I
no, no,
saw.
but you when you mean kids as in now or back then when they said the
Well,
alleged.
we ain't got to that yet.
Well, at the time they said the crimes allegedly happened, they were up underage. The ones that was supposed to been
I
up
thought that.
underage.
Well, I thought that the crime that allegedly happened. Maybe I'm wrong. Maybe I'm in denial. But I don't think so. Was Aaliyah.
No, they ain't the only one. As far as underage,
Who was underage?
they said.
Geronda
Well, it
Bates.
was a few. Wait a minute, it was a few through the Uncharged Act, so I'm not gonna go through them. But
Right.
there was Aaliyah, there was
Right.
Geronda, and there was what's the name? Jane Doe number 5.
They lied.
Oh, okay.
They lied. Maybe I didn't say that right. They
Oh, you said
lied.
they oh, okay.
They
Now
lied.
I mean,
They said
hey,
that they
they
lied. They lied. They said that they lied.
they said they lied about their
They
age,
lied.
right? They said they lied
They
about their age,
lied.
but upon confirmation of what year they was born and all of that, at the time they had that encounter, they were underage.
Yeah. Okay. Yeah. Yeah.
Yeah, but I mean, I kind of split in half with that, right? Because I
Yeah.
know what the law states. A law states, you're supposed to be reasonable to know that you're dealing with a minor and this, that, and third. I get that, right? I just have a problem, and not just that crime. I just have a problem with anybody being tricked into a crime or led to break a crime under false pretenses and shit. I'm trying to figure out why would somebody get 100% of the blame.
Yep. That's what I'm
Because
saying.
my thing is, if I just say that would means that you remove from me that if I knew I was committing a crime, I'd have went ahead and did it anyway. You're saying that I 100% you know that of me, and I say that's not me. Because I know if me myself, I know I'm committing a crime. Depending on what it is, I'm not gonna do it.
What that
I'm just being honest.
what that man said in the Gail King interview. He said this ain't me. He said that. and I'm inclined to believe that Jane Doe #5 told the truth in the Jane in the Gayle King interview. I believe that. Now all this skullduggery and all this lies and all of that, we are looking at it, from, you know, uh looking at it from a street perspective, is that we don't interpret the law like that.
Hmm.
And we understand that people have a lawful duty and we have a moral compass. uh and when we and I feel like I don't want to be off. Hold on. I feel like when we are on these panels, I don't want your audience to misconstrue that. I hate when I didn't like when they said that we were supporting a pedophile. We just wanted the man to have a fair. Well, I did. I felt like I wanted the man to have a fair and just trial, and I don't think that he got that. We can read. I mean, that's just the way that I feel, Angie. I don't feel like he got a fair trial.
Right. And
And
I
first,
have said,
and
no,
first,
go ahead.
I feel like, and then a lot of people, not even addressing, back then when we was on these channels, trying to read emotions and saying what we thought should be emotions. COVID did not do him any justice at all. Ooh, he couldn't, you know what I'm saying? Do the
Mhm.
code, they didn't even take that shit under consideration. COVID shut everything down. This man went through the trial of the century through COVID. Now, if anybody ain't feeling me on that, then I don't know. I don't know what to say.
But when I did that defense exercise, I gave like 5 reasons why people were saying that they felt like he was innocent. And it was nothing about supporting someone that's accused of sleeping with an underage girl. It
Okay.
was, I mean, I gave a realistic because I'm not entertaining that nonsense. Now, if you support that, I don't have nothing to do. I
Yeah.
haven't had that
Out.
conversation.
I'm
That's
out.
great.
I'm
But
out.
yeah, but I'm talking about like he was guilty because due to the acts of others, unconstitutional. I gave the 5. I still got that live is still. I mean, all my lives up except 2 that I got to edit and put up. I mean, I got to do a live and a live, but cotton candy part of yesterday. My oh, okay, cotton candy. But yeah, so I try to give up.
You need to go in there and look and see too, because I think they blocked Skylife out of there.
Let's see.
She was in there about 2, 3 o'clock. Yeah, you need to get her a wrench.
Let me see.
Yeah, because I saw her and then she was gone. I couldn't see her no more.
She could have just left.
Oh,
You
but
know
her
what? The riches over here ain't just for like modern. It's more of a free membership situation. Let me
right.
see.
Okay, I got you. I got you.
Yeah.
Yeah, I know you. I know that. I mean, now that you mentioned it, I get that. But I thought I saw some of her messages being deleted. And shit, that was way back there because it's 5 o'clock. This had to be about 2:30, something like that. Yeah, because I've been in here with you on and off. I was like, oh Lord, I started to get a headache. Ate me something to eat. I said, let me go on back. And then I come back, I look at the channel and the red dot. I jump back on in there. I hung on in there with you.
Yes, ma'am. Let me see. I make sure the people should be blocked. Blocked.
Yeah. I gotta go to work today. I gotta be at work at 7 o'clock.
Mm-mm.
Yes, I do.
You on the Eastern time zone?
Yeah. Wait a minute. It's 5 minutes to 5.
Yeah,
Uh,
Eastern.
yeah, but I've been asleep. I've been asleep. I was off for 2 days. While I was off Monday, I called in today. Shit.
You should have called in for today.
Now you know what? I'm gonna be on the wire. I'm gonna be on the wire. I'm gonna be in and out. You know, that's gonna be exclusive.
Mm-hmm.
Exclusive. And we gonna let God's will be done.
Yeah, that's all you can do.
God, we can do on this one. This is gonna be a bittersweet moment. Shit. And I'm telling you, Angie, when you talk to people in the real world, they say the same thing we say. I ain't, I ain't not yet ran into a person who, you know, I'll keep that one to myself.
Mm-mm.
But you best better believe it's gonna be some documentaries. Cause I want to see what the white folks come up with. Cause the man is loved all around the world.
No, Sky not blocked.
Oh, good.
Yeah,
She
she not blocked.
must have left on out then. Must have left on out. Well, I guess I'm going on back in the chat because I done said my piece. My prayers go out to Robert Sylvester Kelly and his family.
I appreciate you coming on, stopping on through later.
But you know what? I'm glad I was a part of this because a lot of people, they ask me questions. Courtney, you keeping up? I'm keeping up with this shit. I'm keeping up with this shit. Shit. The shakedown and the takedown. This shit was very interesting. Very interesting.
Mm-hmm.
And did you now you read where the girl was stealing, they were stealing?
Yeah, that's what he said. He said it was
Yeah, he
the
said
stealing
it.
and all type of stuff.
Stealing and all kinds of shit.
Like damn, they stealing Mark Kelly. My boy, I'm like, boy, I ain't never heard on this type of shit. This
But
some ghetto
listen,
ass shit.
but listen to this.
Stealing and
Wait a
shit.
minute now. Let me put this twist on it for you. See, people can't understand how much money was coming in that door. This man was doing concerts. Somebody broke it down. He was getting what? 150, a $250,000 a concert. And you go on tour and you doing 15, 16 of them. How many of them? Somebody had the whole thing up for the last some odd years. You can't identify with that kind of money coming in.
You welcome,
People
Melissa.
had
Thank y'all. Mm-hmm.
they had sticky fingers. Them fingers, them fingers was sticky. And he was paying a girl $5,000 and you going to get this man that is entrusted in you to dress him and he's giving you his hard-earned money to go and buy some clothes, and you say the shirt was $300 and the shirt was $150. Man, shit, get the fuck out of here.
What's up, Shanika? Yes, honey. Yes.
Fuck out of
That
here.
was crazy. That I mean, that was a read today, baby. When I tell you
It
that
was.
was a read, I kept waiting. I was like, this is why I kept telling me, this is where the damn shit is gonna be. Right here. In
It,
this part right here.
it was in there for the nosy people.
Yeah, we want mind our own business, baby. I was like,
But not
ooh,
today. Not today. We wasn't. You was up in there.
sure
You was up
wasn't.
in
I
there
can't
reading that shit.
believe I read all that shit.
Yes, you did. God damn. Shit. Shit,
Oh,
you had about 200, 256, 57 people in the chat. And
oh
then when
wow.
it got to the wee hours, it was still over 100. Hit them
Oh
goddamn likes. Hit the motherfucking likes. Cause we got a day to today. We ain't got that much further to go. I wonder now if they going I wonder how the news is gonna cover this because I want to see this. Cause all
wow.
this shit ain't sequestered no more, is it, Angie?
Well, there ain't no cameras gonna be in there, no. But
Ain't no cameras gonna be in there.
we gotta wait till the news reporters or somebody that's in that courtroom that's gonna go out there and bring us the information.
Okay. Well, they say. Well, I follow the Hip Hop Inquiry. He gonna be there.
Well, he say he gonna be there. Oh,
Yeah, he
okay.
gonna be there. Yeah, I follow him. I seen it on his community thing. He say he gonna be in there.
Oh, good.
Yeah. So they gonna they we so the people we gonna have to wait till they do the verdict and the people come outside and tell us.
Yeah.
Mm.
Hey, Dana, ain't you in New York? Dana, I know you somewhere listening. Ain't you in New York? I'm better.
But do they gotta wait in the line again and all that?
Probably, cause that's gonna be probably standing room only now for that.
You, you know that. You know that. Mm.
Yeah.
CNN, NBC. I hope Gail King ass out there. Oh,
Oh
mother
Lord.
shit.
Mm-mm. I'm
Regardless of what came out of trial, she still highway robbed. Yes, she did.
oh wow.
In my opinion, just my opinion, just my opinion, just my opinion.
I don't know. My when I tell you my nerves so damn bad,
Mm,
I'm just anticipating this shit. My nerves is bad.
See what threw us off is when they changed the date. The date is here today.
Yeah, because it was supposed to be today, right?
I thought it was supposed to be the 12th.
I mean, they pushed it back. It'll go to 15th.
Oh, the 15th. Okay.
Yeah, it's supposed to be the 15th.
I knew it was. I knew it was one. I knew it was one.
Mm-hmm. It was supposed to be the 15th. Hold on for a minute. I probably can still hear you. I'm trying to go to the bathroom. I probably can still hear you. It's a while away. Hold on. Can you still hear me?
Yeah,
Oh,
I can still hear you. And you had me, you know what, you ain't see my comment in the chat. I was in there. I understand what you're saying about them toilets. I got 3 bathrooms my damn self. And you had that
Girl, I wouldn't be able to make it, baby.
you had that bleach in there and you don't want to use it. You just put you then you got to go down there and use the bath.
Yeah.
Uh-huh. I already know.
Yeah, because you got to sit in your bowl and stuff, and you're just sitting there because so when you go to clean your, because I do my sink like that, my tub and stuff. So when I go to clean it and stuff like that, I ain't got to, you know, I mean, I ain't got to apply no elbow nothing to it anyway. But you just it's quicker. You know what I'm saying? You just clean all
Yeah,
up and stuff. I done spray. I ain't put you waste my good product and stuff. I done put all in there. I had to go down the hall and use that damn bathroom. Hell,
right. And
I'll be running back, child.
you be tired of clean. I be telling them, quit using all these. Use this main one down here when you come
Yes,
in the door.
yes.
Yeah, cause you
That's
got
how I do.
yeah.
I be having, I'm tell you something, I have to clean 3 bathrooms,
Me
okay? I clean this one, mine in here, and then over there in the main, I clean two because them niggas don't follow direction. When they come over,
that
I'm trying to say, just use one. But they
yeah,
don't want to follow
just,
the instructions. Okay, I just have to clean. But I'm not,
yeah. Mm.
I'm
Boy,
not finna do all that.
now, oh Lord, I'm bumping kills when I on my way to work. Guess I had to we had to bump kills. Boy, and it's so many people in that chat. I mean, they was just going that. I was just cracking up. I said, God damn.
And the first live or second. Cause
And
listen,
the, it's just the shit, all of it. They
oh
was in
Lord.
there. They was in there. They
Honey,
was in
I
there.
was like, baby, I ain't. I look up and see a comment. I said, baby, I ain't got nothing to do with
But
chat
see,
business.
but you know, that's why when I came, I said, I'm gonna finally come on up in here. Remember when I first came in here, I said, well, you know what, you've been in here so long. That's why it's called our channel.
All right,
You know, you got that side that's not for R. Kelly. You got us that's for R. Kelly. And you got people, that's in the middle.
mm-hmm.
Shit, what can you do? But you know what? And a lot of just looking at it from this perspective, this was a trial. This was a hell of a trial
Right,
to follow, and even keep your personal life together.
right.
You you can't let this shit consume you. Shit.
Mm-mm.
Get these crazy ass niggas let this shit just take them straight on out the box.
Let's say that.
I said, well, God, just straight on out the box.
Mm-hmm.
I said, everybody want to be a star. Shit.
Right.
It wasn't no but one star in this, that R. Kelly. And people, you got to understand. I mean, how can I say this? I, I can't. Did you I'm talking about, did you hear? You the one read it to us. When they was on trips, this man wasn't living no motherfucking mediocre lifestyle. Come on
Mm,
now. I ain't gonna
yeah.
I can't drag this man when he down. Can't do it. Can't do it. I ain't gonna do it. Mm-mm. And that's what I meant by, certain morals, certain codes, some people follow, shit. I know plenty of people, uh, you know, in situations, I'm talking about the dogging of the man,
Mm,
because yes, people it be just outright just dogging the man, just kicking the man while he down, just kicking him. I can't see it. Sometimes you gotta look at it. We did listen to you, and other channels when they read transcripts, we did do that, but I still say it was some skullduggery and some trickery, and the federal government is a motherfucker. Shit, Uncle Sugar, you pay your goddamn taxes, cause Uncle Sugar will come and get your ass. You there,
This
Angie?
Uncle Sugar. Yeah, I'm looking
Uncle
at this
Sugar, Uncle Sugar,
paper.
the
Looking at this
federal
paper.
government. You
That's
pay
what you call Uncle Sugar.
Uncle Sugar. That's what I call him. Shit, Uncle Sugar. I'm just off on the tangent.
Oh, wait a minute. Hey,
I'm
Miss Parker. Miss Parker, can you not use Janine's name, please? She not a YouTuber.
I can't see the chat.
Thank you, ma'am.
No, I was just putting some sense of humor in there when the feds, because it taught me a lot about the feds. They a motherfucker.
Oh yeah. That listen. I
Shit.
when I read how they talking about the 30 round shit, I'm like, now you know what? If they don't sat there and listen to his channel, you know damn well no 30 rounds got nothing to do no damn ammunition. You know 30 rounds is some shit. They gonna haul out all kinds of shit. And you talking about 30 rounds mean and they gonna use the cash app talking about they buying ammunition. So the enterprise over there buying bullets. I ain't got nothing buying no damn bullets.
Well, in the eloquent words of yourself, about the bullets. We know we all who all know what that meant. But shit, when that motherfucker turned you don't turn that camera on that damn courthouse or whatever the fuck that paper said he did.
Yeah.
Cause I didn't too much mess with his channel no more. But I read that.
Yeah, yeah, Miss Parker, disrespect will be met with disrespect. But Janine wasn't the one disrespecting you. She ain't him. So I'll be talking about, you know what I'm saying? I'll be trying to leave the family members out. She ain't done shit.
Yeah, shit. That boy was a loose goddamn cannon.
Oh, they go off the chain.
Off
But
the
see, I
motherfucker.
don't be when the stuff like all the I don't be because a lot of times we be live at the same time and I don't be knowing all that stuff. And then when I read it, I'm like, what happened? Oh my gosh.
Shit, but karma is a motherfucker. I said that.
Mm-hmm.
Oh, you, I said that. I said this shit. Looking at the way, some of the other, that mm, shit, somebody was gonna end up in jail.
Yeah.
But you can't dox people. All of that, letting that go on like that. How long you think that's gonna go on? Because you got all these groups out here, when it really hit home, you got these kids that's on the internet committing suicide. It's just a limit to some of the things that people can do, you know
Yeah, yeah,
on the internet now.
yeah.
Shit,
Right.
come on now, this shit, I ain't, hey, mm-mm. No,
Yeah.
nope, nope, nope. I have, at least not on this channel, no opinion on that. But some people do things to themselves. I don't even,
Yeah. Yeah, some people,
you
some
know,
people do some shit that will land them in hot water.
hot water. You can't smoke no,
Yeah.
can't drink no liquor and mix it with no Prozac. You can't do that.
Oh Lord. I don't know how Miss Parker be finding all those hearts and king hats and shit like that. If anybody ever noticed, if y'all ever see me with an emoji, y'all know I'm on my cell phone and I really don't like to use my cell phone and stuff. I be on my computer. Y'all be finding all those damn emojis and shit.
Yeah.
Mm-hmm.
See all these channels light up live tomorrow.
Won't they, baby? Everybody gonna be. It's gonna be lit,
It's gonna be lit up.
lit.
Mm-hmm. I wonder.
I'm
Uh-huh. And all that fussing and fighting, all that shit. Ain't no even no need.
like,
Ain't even no need.
man, I ain't find too much of nothing. I mean, that can even be an appellate situation. This is getting crazy. I got to look at that that damn that argument about that version of the damn thing to see if that's constitutional, unconstitutional or not, whatever, or if they applied it right.
Well, usually in these type of situations, who they let talk first? Like as far as tomorrow, do they have like opening? It's still gonna be like opening arguments or whatever.
Yeah, the prosecution.
Oh, okay.
It's gonna be crazy.
I wonder who gonna be up in there. Cause I read an article on Lizette. She said that life wasn't enough for him. Oh, girl, some
Mm.
yep.
She
I
said
read.
that.
She said that. Yeah, she said that. Yeah, she said that. I see, but all this, um, here I go, Angie. You got to hear me out. All this
Um,
station, you know, that she was speaking on in her article, like her whole life was fucked up. Bitch, we ain't see you the 30 motherfucking years later. What we ain't know you came out the goddamn woodwork. I'm quite sure you've been living your life.
right, right.
They living their life.
Well, I mean, the the docu series brought forth a lot of people, so we didn't know.
Yeah, we didn't know.
Yeah.
I wo- I wonder who wrote that letter. I put in the chat probably one of them Jane Does who wrote that letter said I sent you a birthday card, and they sent it back.
Yeah. I was reading, I was like, what? I said, baby, ain't nobody but I'm thinking JP wrote that. I'm just thinking
Yeah,
her. Some people talking about was Halle. I think it's JP because she seemed like she the only one that would do some shit like that.
yeah, because I think it was one of them Jane Does because they was on the other side. Helly wasn't really on that side, was she? Her
Halle,
her
yeah, but
testimony.
she wasn't a charged act. She was an uncharged act. That's why I
Right,
say I don't
yeah,
think she the one did it.
yeah, because the way that person who wrote that letter was like apologizing, talking about they made her do it. That's what they said. That's what it sounded like to me.
Hmm.
That they made her tell them lies.
Right.
Hmm. Well, I'm gonna get on off of here. I'm gonna fall on in the chat.
Okay, ma'am. All right,
Oh,
ma'am.
I know you gonna go live tomorrow. I'm gonna come up in there.
Okay, yes, ma'am.
All right then. Thank you for having me.
Okay.
Bye bye.
All right. Yes, ma'am. Yes, ma'am.
Good morning.
Good morning.
It's time for you to go to bed. I can hear it in your voice.
Yeah,
Hello?
I got maybe another couple minutes. You hear me?
Yeah, I can hear you.
Oh, okay. Yeah, I got another couple more minutes in me. What's going on?
I'm excited.
Oh Lord.
And
Oh
I am
Lord.
anticipating just as much as you is. So
Yeah,
yeah.
I want to see what the hell is gonna happen.
I
I'm tired
believe
of guessing. I want to know. I'm trying to get a sense of. I don't like the wait. I'm impatient. I don't like the wait.
me too. Me too. Um, I know she's gonna throw the book at him. That's you know my prediction, in my opinion.
She
I
seems
just
pretty. She seems pretty. She got like a. I don't know. It seems like she don't accept that scat sex excuse for the boo boo and all of that. Seems
of
like
course
she,
not.
because she says it's humiliating and all that type of stuff. I was trying to get a sense. I was like, oh, she feel this way. I'm like, oh Lord.
You read all 103 pages.
No, I ain't read all 103 pages. I don't go on. I was reading the parts where
Mhm.
she was giving her, her ruling with regards to it, right? Because I was trying to see what her mindset is, you
Oh,
know.
okay.
Yeah, so because most of it was just stuff that happened during the trial, and then stuff that happened on the motions. Well, I already read that.
Oh, yeah. Okay.
Yeah, that's what
Okay.
it was. That was the majority of it. That was so I was reading what she was saying out her words. I wanted to
Mhm.
hear her words.
Now
That's
about
what I was reading.
yeah about that letter that she got, what they said was from alleged victim. They didn't identify who that was. No one
Right.
knows. Like nobody doesn't know who that is. I said it was Diane Copeland, but she was a prosecutor witness because she even wrote a character letter.
Yeah, you
So
talking about the one? Yeah, I'm talking about the one where um she said he said it was an alleged, it was an accuser, right? You talking about the one, because we got the name, we got the Diana Copeland letter and all. We got that in the
yes,
back.
I'm talking
I'm
about
talking about the
the one that Jennifer has in her sentencing memo. Someone sent in a
yeah.
purple car. Yeah, that one. She didn't identify who it was, so we don't know who it is. But I said it was Diane Copeland. But again, I don't know. So no, like
I
nobody was
thought it read
identified.
like she said if you don't want to talk to me, you'll ride or die. Cause she put a letter in the back from Diana. Well, oh no man, I see what you're saying. I see what you're saying.
Yeah.
Cause in that little part, did she say anything to allude that she
Didn't allude to whoever. Like nobody
did
has
she
no
say?
idea.
Did she say a victim witness? What did she
Yes,
say?
yes. She said alleged victim wrote it.
Okay, so a victim had to be one of them girls, one of the people.
Hey, with him writing all these fake letters, is it really real?
Oh,
Because
that had to be. I
because
mean,
with all those fake letters,
no, no,
like
but this
who
what she
knows?
said.
I don't know. He had people writing fake letters and texts and shit. So, but that's just my theory. Just like how everybody else had theories, we all been through this for
Yeah.
3 years, and the day is finally here. They said they ain't delaying it anymore. The day is finally here. The next up is Chicago, and that's going to be the brutal one. Uh, I see angry people in the chat. It's gonna be more angry people when there's a lot of stuff that's going to be revealed. So, but that's my take on it.
I
Mm,
know it would be. Yeah.
yeah, it's going. So today it's going to be brutal. There's going to be people that's going to be angry. There's going to be people that's going to be excited, which that will be me. And that's that.
Are you gonna argue with Levi?
Why would I argue, Angie? I don't do that.
Child, please.
Why? Why
As
would I
of
argue?
lately, you haven't been probably in the last what maybe year,
Angie,
in the
somebody's
last
telling
year.
you, somebody said, Angie, get that angry biatch off your pedal.
Child, I'm
but
not
I'm,
even,
but I'm,
I'm not even around there.
but I
I'm not
argue,
even around there. I cannot deal with chat
but
business, child. Let me see what the hell is going
I,
on. Let me
I'm
see.
being called. I'm being called
Oh
a miserable
Lord.
ass biatch. Keep a miserable soul. What else I'm saying? Oh, our frog face original lover. Wow, wow. I didn't even. I see. I'm not saying nothing to nobody, but they're saying very mean and nasty things to me. Wow, wow, wow. But I'm gonna let you go
Lord.
because you gonna get your, gonna get off the field. And I will see you later
Child.
in a couple of hours after sentencing.
All, all right, ma'am. Thank you, ma'am.
You
I
take
appreciate
care, and you have
appreciate.
a
I,
blessed day.
I will, honey. Y'all don't tear it up, honey. Shit.
All right, all right.
All right, honey. Bye. Woo. Let's see. Y'all, I'm gonna close out in a minute. Give me 1 second. I'm looking for something. I'm looking for something. Hello. Mm. My nerves bad. I don't know about y'all. My nerves bad. I'm tell you straight up. Well, anyway, let me get on up off cheer. Get on up off cheer, honey. So what I started off with, man on Club Blue. Do, 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 do. Oh wow, that's the Club Blue sign off. And they're opening as well. Oh man, this has been a day. This has been a day. Day. Thanks again to the panel, the host, the hostess, and the guests, and everybody else. Make sure you love each other, love yourself, and do something good for someone else. Until a few hours from now, the next live, love you, appreciate you. And there's another one in the book. Peace.